The House Committee on Ways and Means will now come to order. The clerk will call the roll.
Chair Meyer,
Here.
Vice Chair Theory, Button, Craddock,
Here.
Gervin Hawkins,
Here.
Hefner,
Here.
Munoz, Noble,
Here.
Raymond, Shine,
Here.
Turner.
Are you going?
Quorum is present. If you're testifying, please make sure you have filled out the electronic witness affirmation form on the registration kiosk in the hallway. When testifying, please state your name, who you represent, and whether you're testifying on, for, or against the measure. Also, please limit your testimony to 3 minutes and avoid repeating any testimony that has already been presented. Members, does anyone have any comments before we begin? Seeing none. Chair lays out House Bill 581 and calls on Representative Raymond to explain the bill.
Chairman, thank you so much. Can I lay it out here?
Of course.
Thank you. Members, this is a direct response to rising inflation and affordable housing in Laredo, McAllen, and Brownsville. We have many wonderful HUD-approved counseling agencies providing rental housing to low-income individuals that are unable to administer services due to current law. In just a few minutes, you're going to hear from Neighborhood Works in Laredo, a group that relies on property tax exemptions to provide affordable rental housing. This bill would extend exemptions provided in the tax code to include charitable organizations that provide housing, counseling services, and who provide rental housing to low to moderate income individuals. And low to moderate income in Laredo and McAllen and Brownsville is different than low to moderate in other places north. Trust me on that. And so with that, Chairman, I wanted to be brief, and I appreciate you helping us out because we have our witness that has to catch a flight. So I appreciate it. With that, members, I'd be glad to try to answer questions. If not, Chairman.
Very good. Thank you, Representative. Chair calls Elizabeth Alonzo Villarreal.
Good morning, Chairman, and everybody here, Commissioners. My name is Elizabeth Alonzo Villarreal. I represent NeighborWorks Laredo, and I am speaking for House Bill 581. If I may just, I know there's a time limit, so NeighborWorks Laredo, we've been around since 1991, providing homebuyer education, counseling to first-time homebuyers. So in this term of 32 years, we've produced over 5,900 new home owners that are already producing a lot of property tax revenues in our community. We did a survey for just 260 families out of the close to 5,000 families, 3,600 families. In an 8-year term, they have produced $9 million in property tax revenue in our city. That goes to the city, the county, education. So it is a big impact that and a big service that we are providing our community. We are the only HUD-approved counseling agency in Laredo, Texas, and you need to have HUD-certified counseling counselors to be able to provide education and counseling. Passing 581 would continue for us to provide low-income housing, especially to our veterans and seniors. We had a 40-unit apartment complex ready to go in 2018, but we were informed that we no longer qualified for the tax exemption. This was geared for our veterans and seniors, and I can guarantee you and I can tell you that we have our own United States veterans living in Mexico. I can attest to it. Back when my father was 60 years old, he lived in Mexico. He was a cab driver in Laredo, Texas, and the affordability was just not there. Organizations such as NeighborWorks Laredo, who are a HUD-approved counseling agency, rely on grant writing and revenues that we get from our rental properties. We only have 67 rental units. We're not in the business to make tons and tons of rental properties to make a lot of money. The money we make is to provide our operations, the necessary money to continue operating. And like I mentioned before, all of our new home buyers are producing that tax revenue for our city, county, and education. So we do hope that you can consider this with, all due respect. House Bill 581.
Very good. Members, any questions? Thank you. Oh, Chair recognizes Representative Gervin Hawkins.
Thank you so much for your testimony.
Thank you.
So are we requesting, and this may be to the bill author, that as a nonprofit, the multifamily units that you own would not have property tax attached to it?
Correct.
And that would help make it more affordable by reducing that cost?
More affordable. The plan was to have somebody represent our tenants, to refer them yet to other services that they need. And we have, through our home buyer education and counseling, those tenants of ours, and we just had 2 this month that are transitioning into purchasing their home. So it's not just having a place to rent, but we also provide them with the necessary tools and resources to be able to start saving and getting on track to become homeowners.
Thank you.
Yes.
Members, any other questions? Chair recognizes Representative
Thanks, Chairman. If you wouldn't mind, remind the committee, they didn't start, the appraisal district didn't start charging you or forcing you to pay taxes until when?
2018.
Yeah, so members, this has been around a long time. It's helped a lot of folks. It's a wonderful organization. And is it fair to say that the impact of the appraisal districts changing their position or moving their position to where you had to start paying has had a significant impact on the organization?
It has, because like I mentioned, we were planning on hiring more folks, and you know how rental properties are. You need to be able to sustain them, maintain them. But with this impact, it halted our other project to create 40 new rental units, and we were shovel ready. We had received financing from, a local bank who liked to invest in CRA locations and for future tenants that are low to moderate income families.
And you couldn't move forward because at that point you were gonna have to charge property taxes that these folks couldn't pay.
Exactly. There was
so-
an extra $60,000, and well, like I said, we're a small nonprofit organization, and so that added tax liability would have had to been passed on to the tenants.
Thank you. Thank you.
Thank you. Members, any other questions? Very good. Thank you, ma'am, for your testimony. Appreciate it.
Thank you.
Thank you.
Is there anyone else who wishes to testify on, for, or against House Bill 581? Seeing none, the chair recognizes Representative Raymond to close on House Bill 581.
Thank you, Chairman, members. I hope we can move this bill forward. It is significant in terms of the impact it has on folks who really need help with housing. And in our area, so many of those folks are going to be veterans. I'm going to get fancy with my wording and say it sucks that veterans have to go live in Mexico because they can't afford even to live in Laredo or Brownsville or McAllen. So we've tried to narrow this, as much as we could. But also to the witness's point, the work that they do creates housing in a way that property tax, our appraisal district is going to get their property taxes. So with that, Mr. Chairman, I close unless there are any other questions.
Thank you, Representative. Oh, chair recognizes Representative Gervin.
Thank you, Mr. Chair. I think it's great. So you're saying an entity doesn't have to be a CDC or go through a PLC to be able to get property tax exemption?
I don't know what CDC.
Community Development Corp.
Oh, okay.
And then through the Private Finance Corporation.
I don't know. What I know is that this organization complied with section 11.18 of the tax code until 2018. And at that point, the appraisal district says, hey, you're gonna have to start paying property taxes.
So is this a continuation so
Yes.
that they don't?
From 1991 until 2018. And then and he's retired now, or I'd have brought him up here, but the chief appraiser just decided they would start have to pay taxes.
So any 501c3, no property taxes?
This is 501c3. Well, if we need a question answered, I can. I know Ms. Alonso can. Chairman, would you, just to indulge us for a second, recall the witness to answer?
Of course.
Can you do that?
Chair calls Elizabeth Alonso Villarreal.
Thank you. And that would be for not all 501c3 organizations, but HUD-approved counseling agencies.
Yes, sorry.
That is what we do. And like I said, there's only one of us in Laredo, and we've been the only one since 1991 that provides education and counseling for first-time homebuyers.
Gotcha.
In addition to that, we also provide services in foreclosure prevention. We've saved over 500 families
Thank
through
you.
our education. Thank you.
Thank you. Thank you, Chairman.
Very good. Members, any other questions? All right, thank you. Representative Raymond, do you close?
I close.
Very good, thank you, sir. If there's no objection, House Bill 581 will be left pending. Is there objection? Chair hears none. House Bill 581 is left pending. Chair lays out House Bill 2488. The chair offers a committee substitute and calls on Speaker Guerin to explain the bill.
Thank you, Mr. Chairman and members. It's an honor to be before you today. As it stands now, after a property's appraised value is lowered in the preceding tax year under either Chapter 41 or 42 of the code, an appraisal district has free hand to set values with minimal evidence and will wait until a Chapter 42 lawsuit is filed. At that point, the burden of proof unfairly shifts to the taxpayer to demonstrate the appraisal district's newly determined value of its property is excessive or unequal, despite the preceding year's judicial determination lowering the prior year's appraisal. Nothing in the plain text of Section 2301E indicates that an appraisal district is relieved of its burden of proof in a de novo appeal. Moreover, the purpose of 2301E is to prevent repetitious litigation over the same set of facts and issues year over year. In simplest terms, 2488 is trying to make clear and give effect to the changes in law made by the legislature in 09 and 19 to protect property owners from having to fight the same appraisal increase every year. HB 2488 makes clear that if a taxpayer protests their appraisal and they prevail in getting the value lowered, then the following year, if the appraisal district wants to raise the same valuation, then the appraisal district must prove the increase in valuation by clear and convincing evidence. And this is personal to me. We had to sue the appraisal district pre-COVID, and obviously because of COVID, it took a few years to get through, and then further delays by the appraisal district in signing the agreement took a little while, but we prevailed, and we didn't anymore prevail, and then they raised it back to the value that we protested. And I have a couple of witnesses here today, or several, I think, and I'm sure the appraisal district doesn't want to have to work so hard that they have to prove that the new value is justified, although they agreed to, or the court decided that it wasn't. And I'd be happy to stand for questions, and otherwise I'd reserve my right to close, Mr. Chairman.
Thank you, sir. Members, any questions?
Thank you.
Thank you, sir. Chair calls Karen Evertson. Ma'am, just real quick, can we clarify who you're testifying on behalf of? And you are registered twice. May we combine your registration to one?
Yes, I apologize.
No, you're fine. Oh,
I tried to eliminate the first registration, but it only wanted to let me eliminate the second.
understood. No problem at all. Thank you, ma'am.
Who's she registering from?
Okay, and so who are you testifying on behalf of?
Texas Association of Appraisal Districts.
Thank you, ma'am.
All right.
So good morning, Chairman, members of the committee. My name is Karen Evertson, and I am here on behalf of the Texas Association of Appraisal Districts, and we are respectfully opposed to this bill. Now, I don't have a lot of time to go into what is a standard of proof and what is the burden of proof and the requirements when you're the party asserting a claim to court. So I will just start with this. In Texas, when governmental immunity is waived, our laws require that the state be treated in the same manner as other civil litigants. Now, this is the state and its political subdivisions, which include the appraisal districts that operate on behalf of citizens of the state of Texas. Now, this provision is codified in Section 4223A of the Texas Property Tax Code, and this is no accident. Because as you are probably aware, there is a long administrative procedure that takes place before a property owner or an appraisal district appears in district court before a judge and a jury of its peers. So the issue we have before us is that a property owner has gone through the administrative hearing, and I would respectfully clarify something that Representative Guerin identified, which is that you're starting off with minimal evidence from the appraisal districts. Well, I would invite you all to look at the two sections that are referenced in this bill, and they both identify that unlike our normal protests, and again, I'm still speaking at the administrative level, which have a burden of proof on the appraisal district by a preponderance of the evidence, when the value has been lowered in the prior year, the appraisal district doesn't get to come in with minimal evidence. It's at the administrative level that they must have clear and convincing evidence. It is only at that point when the appraisal review board issues a determination of value that a property owner can choose to appeal that decision, and that's language that's used very specifically throughout the tax code, that they can appeal this decision to district court. The challenge with the provision as written is that in civil litigation generally, when a party goes to the court and they are seeking relief from the court, they have the burden of proving that they're entitled to the relief they seek. This bill would turn that long-standing provision of jurisprudence on its head, and it leaves more questions than answers. Specifically, in most cases, if a party has the burden of proof and they fail to meet that burden, then they do not prevail on their claim, right? Makes sense. In these cases, you would have a property owner coming forward and saying, after my administrative hearing, after the appraisal review board, which is a separate legal entity, after they set a value, I'm still dissatisfied. My value is still too high. And what this bill would say is, okay, appraisal district, you prove the claim. Well, what's confusing about this is it doesn't identify if the appraisal district has the burden of proof, what claim is it on? Is it on the property owner's or the plaintiff's claim? And if so, what if the appraisal district fails to meet its burden of proof? Then is the claim dismissed and the value goes back to the administrative value? I don't think that's what they said, what they were intending by this bill, but the fact is, you take a very, very complicated area of law and you try and reduce it to a one-sentence change, and you're going to leave more questions. In addition, if the appraisal district is told, no, you have the burden of proof, what value is the appraisal district being burdened to prove? Is it the prior year's value? Is it the current year's noticed value? Is it the appraisal review board's administrative decision? Keeping in mind the appraisal review board has exclusive jurisdiction and quasi-judicial authority. Or is it a third-party expert that the appraisal district would hire to support its opinions? As a party with the burden of proof, typically that party has the privilege of opening evidence at trial and presenting the last argument at trial. This bill does not address that change would take place because typically in our courtrooms, a majority of the litigation is filed by large-scale commercial property owners suing the appraisal district over the value determined by the appraisal review board. In addition, this still leaves a question for those of you that are lawyers and care to share this with your brethren. What would happen if a directed verdict were filed after the presentation of the initial evidence if the appraisal district has the burden of proof? One thing that was noted is that there's nothing in the tax code that says the appraisal district is relieved of the burden of proof that it carries at the administrative level. Well, what does answer that question and does state it is the language of 4223A itself. And that is that these cases are to be tried in the same manner as other civil litigation. And what that means is that the district court, quoting 4223A, shall try the issues of fact and law raised by the pleadings in the manner applicable to civil suits generally. Well, when the pleading is filed by the property owner, it is unclear how the appraisal district can carry that burden of proof. We would be respectfully opposed to this, Your Honor, members, sorry, force of habit, Your Honors. Because this bill does not clarify this massive change. It's not a lot of words to the statute that are being proposed, but the implications are massive and will have ripple effects far beyond just, oh, the appraisal district has to prove its case. And one last point, keep in mind that it's only after the appraisal district has proven its case to the administrative quasi-judicial body by clear and convincing evidence that this case would even be going to district court. I wonder if you have any questions, I'd be happy to answer.
Members, any questions? Chair recognizes Representative Shine.
Can you give us an idea of how many, on a percentage basis, from your perspective, how many of these types of cases go to district court?
I do a lot of litigation for the Travis Central Appraisal District. I can tell you that this year there were in excess of 1,700 original petitions filed. That's not including cases in which an existing lawsuit was amended. So when you talk about the number that actually go to trial around the state, I can tell you that I've had 3 cases that went to trial in the last year. 2 were jury trial and 1 was a bench trial.
You're representing the Association of Appraisal Districts, is that correct?
The Texas Association of Appraisal Districts,
So is
yes,
that
sir.
information available from a statewide perspective?
I anticipate it is.
Okay. So this clear and convincing evidence, I mean, you're talking, this is not a very short period of time to have something like this take effect. If someone's gone through, they've met with their appraiser, they've gone through that process, then gone to the appraisal review board, and then from the appraisal review board, they choose to go on there and go to district court. To my knowledge, I don't know that a lot of issues go to the district court. Most of these things are settled by the appraisal districts for the most part.
Oh, I would absolutely agree with that. The appraisal districts do an amazing job around the state, negotiating and working with property owners in order to save taxpayers and the courts time and money.
So I would think that a property owner who's willing to go to district court apparently has some very compelling reasons as to why they want to go to district court in that regards, okay? And then to go through that entire process, which probably is going to take, what would you say, at least a year to 18 months?
It depends on the court.
Longer than that?
It does depend on the court.
And what we basically do then is we put property owners in a situation where they're filing a lawsuit, and then if they're successful in winning the lawsuit, then they're having to turn around again and have to defend the same type criteria when we're talking about this clear and convincing evidence. I mean, I've looked at a number of these situations across the state for the last few years, and I find it rather interesting that a lot of appraisal districts seem to be feel like they're more guardians of the state than they are for the taxpayers as well. Don't you have a dual role in that regards?
Absolutely. Appraisal districts are going to represent the interests of the citizens and that are their constituents and the interest of the state, the taxing units for whom they are establishing a value. However, it would be my point that it is rare, if unheard of, well, I won't say unheard of, I do know of one circumstance where an appraisal district or a property owner doesn't take instruction from the court's prior holding. And if you look at 2301 and Chapter 41 that are addressed in this bill or referenced in the bill, those aren't limited to holdings from the district court. If the ARB lowers the value in a subsequent year, it would be held at that value. And ultimately, Representative Shine, it comes down to the fact that the appraisal district accepts or has accepted the decision of the Appraisal Review Board, which is a separate quasi-judicial body that sets this value. And if the appraisal district has accepted that value, then it seems inherently contrary to both our laws relating to governmental immunity and just fundamental fairness that the appraisal district would bear the burden of proof on a value that they agreed with and that was established by a third party.
Do you think, in your opinion, that maybe what we need to look at in the tax code is that if there is property that goes as far as to the district court, that possibly there be some type of period after that, that property owner has some relief because of the process for at least the next tax year without having to worry about this proving evidence or going to clear and convincing evidence from that standpoint? So if you have a court that renders an opinion in favor of the taxpayer, that should have at least a following year of relief for them?
Well, I'm going to give you, if you will, two answers. One, as an individual property owner, sure, I'd love that to stay. But then I'm going to give you my answer as a representative of the Texas Association of Appraisal Districts and the taxing units that rely on the appraisal district's information. And that is, in the Texas Property Tax Code, each tax year stands on its own. And if you do not consider the market conditions as they change, you are shortchanging not only your taxing units, but the taxpayers in the state that rely on those funds for public services. Austin is a massive example of that, unprecedented from any appraiser that I've spoken with. And the value changes that we saw within a 12-month period were shocking. And if those values were held from a prior year's administrative proceeding, think how unfair that would be for the taxpayers that come forward in the present year, that their neighbor's value is being held to the prior year's value. It violates our constitutional obligation to have equity in our appraisals. Well, equity in taxation, which is based on the appraised value. So although I recognize the challenge of coming forward when you were just there the year before, that is the process that this legislature has set up, which is every tax year an appraisal district is burdened to go out on January 1 and say, here's the value as of today with today's market conditions. And by sidestepping that for the few that know how to utilize the system, it creates and injects inequity for other property owners.
Are you required to review the appraisal value of that particular property every single year or every other year? Isn't there a time frame there that property is reviewed at another? Go ahead.
Appraisal districts can set a cycle of review where they will go back and reanalyze categories of property, but there's nothing that limits that to every other year. The tax code burdens appraisal districts with coming up with an appraisal, with a determination of value every January 1, every January 1. And so to ask, do they review it every year? Absolutely. And if it was reviewed in the prior year and the Appraisal Review Board or binding arbitration or the State Office of Administrating or a district court lowered that value, the appraisal district still has the obligation to go back and look at that value as of January 1. But the challenge or the difference as it currently stands is when they present those findings to the administrative body, the Appraisal Review Board, they must prove to that Appraisal Review Board that the value is going up based on clear and convincing evidence, not the typical preponderance of evidence.
In your opinion, is there anything that could be done that would give the appraisal district the opportunity to consider the lawsuit that occurred previously? Since we're talking about going through a pretty good process here of going with the appraiser, going through the ARB, which is extensive, and then all that's required to go through before you even go to district court, because by your own testimony, very few of these even get to district court, okay? That would be maybe some remedy or some recourse that would allow property owners to have some reprieve after going through that process in the next round?
I think the reprieve is that the appraisal districts do not wish to go to district court. They don't wish to frivolously, not to use that in the legal term, but they don't wish to frivolously spend taxpayer dollars fighting values. And that's why I was trying to indicate most appraisal districts, every appraisal district I've ever represented takes it as instructive the district court's actions in the prior year. So if we've had a relatively stable market and I sue on my downtown office building, which by the way, I don't have a downtown office building. That was just by way of example. But I sue on my downtown office building and the appraisal review board lowers that value. Well, then the next year, the appraisal district is going to look at that again. And I will tell you that the appraisal districts I represent will look at the actions of the appraisal review board, the reasoning of the appraisal review board, if it's available on the record, and consider that when they're setting the values. And certainly if it gets through the appraisal review board and the property owner is still not content with that value and they file a lawsuit, an appeal of that decision, then the appraisal district is well aware. They already know how a judge or a jury is going to view this property. And absent some pretty compelling evidence, clear and convincing evidence, they're not going to want to spend time and money on that lawsuit.
Do you know in this particular case, are you familiar with this particular?
I have no idea what
So
lawsuit.
you don't know if there were some procedural issues associated with this?
Can you tell me which case this was?
As was testified a moment ago by the author of the bill, as far as procedural issues for the purpose of remedy that may have to take you all the way to district court to get a reprieve, I guess, or grievance in this particular case. So, okay, so if you don't know the answer to that, just disregard. I mean.
But that does bring up an interesting point related to the recovery of attorney's fees, because as the tax code currently stands, a property owner that prevails under a market or equity claim can make a claim for attorney's fees. So in the situation you're discussing, if the appraisal district failed to follow some procedural requirement set out by the tax code, I think that would be a very strong argument for that property owner to argue for the recovery of attorneys.
And when you say appraisal district, you're referring to the ARB as well, is that correct?
No, the appraisal review board.
Because they can have a recourse with the ARB as well.
The only recourse allowed under the Texas Property Tax Code against appraisal review boards is the failure to grant a hearing to which the property owner is entitled. So once the appraisal review board grants a hearing, then there is no recourse available against appraisal review boards. The tax code says you can sue the ARB, you can sue the appraisal district, but you cannot sue both in the same lawsuit.
All right, thank you.
Members, any other questions? I do have two, just talking about the volume of cases and picking up on Representative Shine. This bill only applies when your taxable value is, or your appraisal rather, is lowered the preceding year and then increased the following year, correct?
That is my understanding. Yes.
Okay, so it's very limited in nature. And then I appreciate your advocacy and certainly get that, but I got to tell you, I don't understand why, and I just don't understand why the folks who are appraising shouldn't be held to a higher standard to prove that. The homeowner has zero say in the appraisal until they go ahead and object to it or so forth. So if the appraisal district is doing its job appropriately, I have zero idea why they have a problem with proving what they have determined. Can you explain that to me?
Yes, Chairman, I can. Because you have to understand, this is a multi-layered system. The appraisal district has the burden of proof at the administrative level on all market and equity cases. So when you say, gosh, the appraisal district ought to have the burden to prove this, they do. Every January 1 for every property owner that chooses to protest. It's only after the property owner has gotten some resolution on their protest and the appraisal review board issues an order. It's only at that point that a property owner chooses, do I want to sit with the value established by the appraisal review board, or do I want to take it to district court and appeal that decision from the quasi-judicial body? So it's only at that point, when the property owner wants to go to the next level, that the property owner bears the burden of proof and the appraisal district defends its value or presents a third-party value.
But if the appraisal district has appraised it correctly, why would they have a problem with carrying the burden of proof?
Because at the administrative level, the appraisal district is limited to that information it can garner from public resources. So when you say the appraisal district has the information, I would respectfully disagree and say when we're talking about downtown office buildings and we're talking about apartment complexes and manufacturing plants and IT tech companies that have come to town, the appraisal district actually has very little information from those property owners. And so what this is suggesting is that
So are they appraising without adequate information? Is that what you're telling us?
they're appraising with as much information as the legislature allows them to have.
Which should be enough, when you appraise my property, to be able to come in and defend it. You, being appraisal district, you need to come in and defend how you appraise my property.
And they absolutely do.
Well, sure. So why don't, so again, respectfully, I don't understand why we have a problem with this when the appraisal district is the one appraising the property. I have no say. I don't get a say. I mean, if they want to listen to me, I'll sure as heck tell them every day how much my property should be worth, but they don't, unless I go and protest. So I'm still lost as to why those who are actually appraising, being the appraisal districts, are here testifying against Speaker Guerin's bill because they don't want to defend their body of work. And I get it's higher. I'm with you. I'm a litigator. Yeah, but so what? Yeah, we both know that if you're going to meet your burden, you're going to meet your burden. And if you're confident in how you've appraised a property, then you should have zero issue with what the burden of proof is. You should have zero issue with it because you've done your work, you've done it appropriately, you've done it correctly, and this is why the value is appraised at X. And so I'm just at a loss. If you've done your job and you've done it correctly, why anybody, appraisal districts in particular, would have a problem with defending their work.
And I would respectfully respond, they do not have a problem with.
But you're here
defending
testifying against
their
it, so
work.
clearly they do have a problem.
If I
'Cause
may.
Sure, hold on. They're here against it, so clearly they have some sort of problem with defending their work. I mean, otherwise you wouldn't be here against it. And again, very limited nature, right? Lower one year, higher the next. Here you are saying, hey, look, we don't want to be held to a higher standard because, although we're the ones who appraised it, we're the ones who gave you the value, and we're confident in that, and we did it correctly. No. Lower standard. It should be on the homeowner. I am at a loss for why you all would be against it.
If I may.
Sure.
Points.
Please.
Because the value that is appealed is not the appraisal district's number. That is no longer the value determined by the appraisal district. That is a value that is determined by the appraisal review board. It is the appraisal review board order that is appealed.
But the appraisal review board works with the appraisal. Okay, that's fine. I mean, you can give me the nuances here or there, but I appreciate it. And really, you're doing, it's an officer. You're doing an excellent job at your advocacy. I just am lost when I come back and be like, all right, practically speaking, what are we, whether it's the appraisal district, appraisal review board, someone has got to defend the value. And at a higher, whatever the standard is, just come defend what you've appraised my property. I just don't know why you'd be, if you're, again, appraisal district, appraisal review board, whomever, you should be confident in the appraisal that you provided to a homeowner, to a business owner, to whomever. And that's why I'm, again, still at a loss for why you're against it.
Well, so the first is, as I stated, it's not the appraisal, it's no longer the appraisal district's value.
So the appraisal district disowns what the appraisal review board does?
It's a separate legal entity.
It doesn't matter about, I'm not talking about legal. I get that. But, so the appraisal district does not stand behind what the appraisal review board determines?
No. As a matter of fact,
Oh,
that's why.
very good. Okay, that's good to know.
That's why the appraisal districts are given the opportunity to file an appeal if they disagree with the value determined by the appraisal review board. Frequently, the appraisal districts say, okay, someone heard it, they didn't believe us, the value was lowered, we're just not going to file suit. Sometimes the value is lowered so significantly that the appraisal district says, we have to speak up on behalf of other taxpayers, and they will file suit. That happens extremely rarely. But I want to address your question specifically. And Chairman Meyer, you have a good point, which is, hey, it's a value, defend it, right? That's what you do all day, every day. But the problem is, once you get to district court, the appraisal district does not get to frame the claim. So I have a couple of questions that I would ask you to consider when you're looking at this bill. Let's say the property owner says, I'm only going to appeal equal and uniform. And the appraisal district says, well, yeah, but we believe there's market value evidence out there as well. And currently, the situation is the appraisal district isn't even allowed to tell a jury that the property sold recently. And so I would say, if you're going to put the burden of proving a value back on the appraisal district, then you have to give the appraisal district the same ammunition, the same bargaining, same advocacy skills that they had at the administrative level once you get to district court. So at the administrative level, we're allowed to, the appraisal district's allowed to tell the property owner, here are other competitors, here how they are appraised, here's what they're getting in rent, here's their income. We share all that with the appraisal review board before they make their decision. So if this esteemed body says, we're going to put it back on the appraisal district to prove that one value, then what I would suggest is that the appraisal district then ought to be able to define the claims that they are being burdened to prove. And so if the appraisal district prove this value, whatever that value may be, then don't tie our hands behind our back and say, property owner chooses what they appeal. Property owner has all of their information about their property. And now you have to advocate this in a manner that's different than any other civil litigant in the state of Texas. If I have the burden of proof on my claim and I lose, I walk out of the courtroom. I didn't convince the judge. But this flips it on its head, which is the property owner.
And empowers the property owner, right? That's what this bill does.
I would respectfully disagree. I think that when you walk into.
Certainly can. I'm going to disagree with you, so that's fine. This empowers the property owner. That is the way that I see this bill. And that is the way that I feel our job here is to protect the property owner and make sure that their day in court is something which I didn't appraise it. You all did. You can give me the semantics as appraisal review board, appraisal district, sure. And so I feel like this bill helps empower property owners to say, all right, you appraised it. We're here at district court, and to Representative Shine's point, I am so serious about this. I am going to district court because I disagree with you so vehemently. And all this does is say, all right, prove it to me. And we're going to disagree on this, Ms. Everson, but that is where I see this bill. So thank you, ma'am.
Mr. Chairman, can
Chair recognizes Representative Hefner, and then we'll do Representative Shine.
So I'm just a small town country boy, so I'm kind of getting lost in a lot of this fancy lingo here. So what I'm understanding that this bill does is once a taxpayer has taken this protest to the appraisal district and then to the review board, and they're not satisfied with what they got there, they take it to district court. The district court rules in their favor. And then the very next year, the appraisal district goes right back to where they started from. Doesn't this bill just say, once this process has played out all the way through district court, you can't just come right back and hit the taxpayer again? Only then does it flip the burden of proof, right? After it's already been through this big, long process. So it seems to me like it's just protecting the taxpayer from having to go to court, district court, year after year after year.
So, no. It's in part correct, because the standard, the burden of proof, doesn't just change when the value was lowered as a result of a district court proceeding. The value, the flip occurs anytime the appraised value was lowered in the preceding year. So if you go to the appraisal review board in 2020 in Austin, Texas, and they set your value, and you say, okay, I'm done. You don't go to district court.
Yeah, but how many times have they decreased our appraised values? Like, how often does this actually occur? I don't know about you, but my property hasn't decreased in value since I've owned it. And that's been over a decade. So I'm not really sure how I appreciate your point, but Mr. Hefner, like, how often is this actually going to occur? Like, how often is the appraisal district or ARB going to reduce my value? I just haven't seen it. And so I'm sure that occurs somewhere but it doesn't occur where I live. And so therefore, respectfully, I appreciate, again, the nuances in your argument. This is not happening that much. And to the extent, to Representative Hefner's point, it is protecting the taxpayer.
It is, if I may, I don't want to, if I'm not invited to respond, it happens a massive amount. What you need, what I would request that you keep in context is the massive number of cases that are filed are not filed by individual property owners. So when we talk about protecting the individual property
So we're
owners,
protecting business owners
we're large-scale commercial business
or small,
owners.
right? Large or small businesses.
That's true, but when you talk
But
about,
businesses are the ones, I get you, because right now there's no cap to their appraisal, which I hear is a good idea, is that the fact that they're the ones who contest and protest, but, so, okay, fine. I'll take your argument and say, all right, more business owners than homeowners, but we're still protecting property owners in the state of Texas, and you're making a distinction between business and home, got it? But we're protecting business owners then, as well as homeowners.
But consider this. So you own a large downtown office building in Austin, Texas in 2021. And the ARB cuts your value in by a third, okay? So the next year, 2020, I forgot what my example was, 2021. In 2022, you say, hey, my value is kept where it was last year. But your neighbor downtown office building just bought it 8 months before. They're going to be valued at their full market value in an equitable fashion, right? So now you have two things going on. One, do we have inequity in the system because the new owner doesn't have the advantage of the prior year? And the second issue is our equal and uniform statute under 4226, which says the new property owner gets to take the appraised value of his competitors in the prior year and find the median appraised value. Well, Chairman Meyer, if your downtown office building has been lowered by a third, and that new property owner uses your property as a comparable to say, I'm not being equitably appraised, what does that do to the new property owner's value? It lowers it by a third. And if that's what this esteemed body wishes to do, then by all means, that's.
So it would lower the taxable value?
Yes.
So we'd lower their taxes?
For the new property owner.
100% on board. Okay, very good.
Okay. And that's what I'm saying is if you make the informed decision that by holding a lower value in the prior year when market values increase, you are in essence bringing down those values below where the appraisal district is burdened to place them. So, of course, the esteemed body will do as it will do, but we just hope you will consider the ramifications and the limited language in the bill.
Understood, thank you. And Representative Shine.
Okay, your arguments are well received. I don't necessarily agree with some of them, but they're well received. So let me ask this. Oh, by the way, for the committee, there were 27 cases tried statewide in district court in 2021. Okay, of I don't know how many thousands, but there were 27, and that information is from the comptroller's office. Okay, so after the ARB makes a decision or district court makes a decision, what I hear you saying is that does not establish a new basis for that property. Is that right? Did I understand that correctly, or did I misunderstand it?
I must not have been very
For
articulate.
the property value.
The property value, if it is lowered in the preceding year, stays at that value unless the appraisal district can demonstrate clear and convincing evidence at the administrative level, where they have the burden of proof, that the value should go back up to the indicated market value or equity value.
Okay, and you've talked about market value versus equal and uniform. And I know that there are some appraisal districts that don't want to use equal and uniform. They just want to use market value. Isn't that the option of the property owner to choose that course of how their property is to be valued? I'm just looking for your answer.
The Texas Property Tax Code currently gives the property owner the right to elect the remedy under which they wish to go to district court.
Okay. Can the appraisal district choose, though, to say, we're not going to recognize equal and uniform in the valuation of your property, we're only going to look at the market value of your property?
No, an appraisal district in trying to establish and set all properties at 100% market value would achieve equity.
So if a appraisal district does that, is that a violation of procedure, in your opinion?
If they ignore equal and uniform,
If they basically tell the property owner, we're not going to consider equal and uniform, we're only going to consider market value. And the
if they-
property owner wants to use equal and uniform.
yes, yes, because the tax code mandates that appraisal districts do both equitable appraisal and appraisal.
So procedurally, what's the property owner's recourse at that juncture if they're not allowed to use equal and uniform, they choose they want to use that? Then they can go to the ARB, is that correct?
Well, if they receive a notice of appraised value.
No, they're meeting with the appraiser and going through the process.
Okay, so the example you're giving me is prior to the administrative hearing,
Prior to going to the ARB, right?
Right.
It's the informal.
the appraisal district says, we're not going to look at equity of the property.
Okay.
Then absolutely the property owner, I would advise a property owner to go forward to the appraisal review board hearing.
All right. And then, the other point is property value study kind of drives a lot of the decisions that's made by the appraisal district as well, because of the funding for schools. Is that accurate statement?
That is incredibly broad for me to answer. Of course, an appraisal district considers the
So-
property value.
So if you have an appraisal review board, and I realize you've made a statement a couple of times that the appraisal, whatever the ARB does doesn't have really anything to do with the appraisal district. But if you've got an appraisal review board and 68% of the people that go before the ARB give a reduction of about 25% on the average of property values, what does that data indicate to you as someone that's in the appraisal district? If you got an ARB that 68% of all the people that come before the board, now they're going past the informal, and they reduce property values by an average of 25%, what does that tell you? I'm curious, I just want your opinion.
I'll give you my opinion. And so I'm not speaking for the Texas Association of Appraisal Districts when I say this. But as an attorney that has represented and advised appraisal review boards, they're people. They're not lawyers. They're not legislators. They're not judges. They're people. And people in their community come in and say, my taxes are high. I've been on a fixed income. My competitors make more money. I'm not going to be able to stay in business. And it tugs at their heartstrings. And they play a very important but preliminary step in the whole process. And I think a lot of what drives our appraisal review boards is sympathy and kindness.
Okay.
Okay, I know you wanted some lawyer frothing at the
No,
mouth
I mean,
response,
you're a
but-
professional in that arena, and I was curious of what your perspective was, okay? Because when I see data like that, and I understand how the property value study drives a lot of things that are done in this process, but 68% of folks that go before the ARB, if there's a 25% reduction on the average of property it goes to me, that statistical knowledge says, something's not exactly right here.
Well, let me counter that with a question, Representative Shine, that I don't have the answer to.
Okay.
But how many of those same districts fail or are outside of the acceptable range of the comptroller study after the appraisal review boards lower those
The
values?
PVS, what you're referring to? There are some, and I know that there are some appraisal districts that have failed as many as 7 or 8 times
Right.
sequentially, okay? Which I find that to be somewhat appalling as well.
But the values that they have to live with are the values that are established by that same appraisal review board that lowers the value by 25%. The comptroller's office doesn't say what was the noticed value initially. They say what is the certified value, which is the value established by these appraisal review board members.
You've held your ground very well. Thank you, Mr. Chairman.
Chair recognizes Representative Gervin Hawkins.
Thank you, Mr. Chair. We won't belabor the point, but I'm confused. I'm with the chairman. Rarely is property value reduced. And if we looked at the conditions under which property value is reduced, let's say, I like your example, the downtown high-rise in Austin, right? And so my 2021 value may be reduced because I'm doing massive renovations or some things have happened and destroyed the integrity of the building or whatever. So then you brought up the new building would have the higher rate because, you know, they're looking good and there's no problems. Why would that fit into the equal and uniform when the value of the property that went down is no longer equal and uniform because of the devastation that occurred? So to me, that would be outside of that. So rarely have I ever seen, well, I've never seen property appraisals go down. So what is a situation where the value would go down significantly, a third like you said, and then is compared to another property that's similar to? I haven't seen that ever.
I see that almost daily, respectfully, Representative Gervin Hawkins.
Really?
I do.
Under what conditions though?
The property owners will bring in a grid that lists, here are my competitors, and here is the value at which, here's the certified value after the appraisal review board process is conducted and concluded. And the appraisal district is bound to use not its noticed value, not the value they originally determined based on market evidence that they've gathered, but they have to use the value set by the appraisal review board. So a 25% reduction, a third reduction. And that owner of the new building is going to come in and say, I have a right to be taxed equally with my competitors.
But it's not a competitor if the building was destroyed at that 3% reduction. So how is that equal?
Well, because I have to get to district court in order to argue to a judge that the comparable property utilized really shouldn't be considered as a comparable. But that's a long process. Just like we identify, it's a long process for property owners. It's also a long process for the appraisal district because the property owner isn't going to identify, oh, the comps I used are inferior. They're going to say, these are the lower value comps I'm going to use so that I can have a judge, a SOA officer, a binding arbitrator say, oh, we need to bring down your value to match your competitors. It is injecting inequity into the system. And that's...
So with all due respect, it looks like the builder isn't the problem. It looks like the appraisal district and the review board need to get in alignment.
Representative, what I would say is where do you think we get the information related to the lowered value of that potential comparable property? The appraisal district is dependent on gaining that information from those other property owners. And so if we get to district court and the new building, right, the new building is suing us because their value after the appraisal review board is too high. I'm not going to be able to go to their competitor and say, how much did you spend on renovations? They're not going to tell me, nor do I have authority by the court or otherwise to force them to tell me why their value was significantly lowered at the administrative level. All I can utilize, what the tax code and the courts have said, all that my client is allowed to utilize, is that certified value from the appraisal review board. So the new building owner is going to go and find your value was lowered last year, your value was lowered last year, your value was lowered last year. Those are now my comps. So I'm a new building and I'm using these comps that have lowered values.
So the review board can't say, yeah, your comps are lower, but here's the conditions in which those comps are lower.
If in the 5 minutes allocated to appraisal district testimony during ARB hearings, that information is 1, available, 2, provided, and 3, comprehended by the appraisal review board, that is certainly something an appraisal district would attempt to present at the administrative hearing.
Yeah, I see multiple problems. Thank you.
There's multiple problems.
Members, any other questions? All right. Thank you, ma'am. Appreciate it.
Thank you.
Chair calls David Keltner.
Good morning. I'm David Keltner. I'm from Fort Worth, Texas. I'm here to testify in favor of House Bill 2488. Clear and convincing evidence has been a part of the appraisal process since 2019. It was also put in a change of the burden of proof in 2009. Our problem is this. Two Houston Court of Appeals from the Houston First Court of Appeals rendered opinions that basically say that that change does not apply to a trial de novo, even though the amendment was to Section 23.01, which says it applies to appraisals generally. Now, that was a surprise to us, and that obviously was not what the legislature, I think, intended, given the legislative history. That's the reason for us coming to you with this bill. The appraisal districts, I don't know what the association thinks, but I'll tell you what the Houston Appraisal District, Harris County Appraisal District said. They said that the clear and convincing evidence was only to the chief appraiser who, in his mind, convinced himself that it was clear and unaffected that the appraisal went up despite less than 12 months ago, a district court made another decision. That's why we're here. Let me answer the questions. And what this bill does is change 42 that deals with trial de novos. It makes it absolutely clear what the legislature had intended. Let me answer several of the questions posed. Would it make what is appealed? What is going to be appealed is the ARB award. That is what the burden of proof will be on. It cannot be any different. What happens if it's a directed verdict, we're asked? Well, we deal with that already several places in the law. We deal with it in punitive damage, as you know, or exemplary damages under Chapter 42 of the Civil Practice and Remedies Code. It's in the Family Code for separate property tracing. It's also in the Family Code for parental termination. And additionally, defamation cases constitutionally have always required clear and convincing evidence. So we handle it the same way as we handle other types of cases. This actually balances the equities, because here's what really will happen. The appraisal district appeals, and the issue is this binding on them? Like a prior judicial determination would normally be by res judicata, issue preclusion, or something. Is it binding? No. Something can change. And the appraisal district, if you have the huge valuations that go up, or somebody builds an apartment complex on the lot, or a house gets torn down and a new one built, clear and convincing evidence of a value going up. In other words, what we have proposed, we hope, is a narrow exception. You pointed out that there were 27 cases in Texas tried, but how many of those were with a previous reduction in the prior year? I'll wager probably less than 5%. The problem is what the legislature was confronted with, and this is the last thing I'll say, was with several property owners that appeared before it in 2009 that indicated in 3 years and even in 4 years running, they would appeal, get a trial de novo, reduce the property appraisement, only to see the chief appraiser and the ARB raise it exactly where it claimed to be before. So we were trying the same lawsuit over the same facts time and time again. That makes money for lawyers, but it's sure not good public policy for Texas, and that's why I support this bill.
Members, any questions? Yes, Chair recognizes Representative Raymond.
I apologize. Thank you, Chairman. I'm not sure, I may have missed whether you spoke to this, but what experience have you had? What amounts are we talking about? Increased, but you've worked on some of these, right? You said?
I have not worked on many of these. I'm an appellate lawyer. All I do is...
But are you familiar with some of them?
Rob Myers, who's up next, will be able to talk more about that. I just found this anomaly and found it so important that I thought it needed to change. I don't do this normally.
Thank you.
Members, any other questions? All right, thank you, Mr. Keltner, appreciate it.
Thank you.
Chair calls Robert Myers.
Good morning. I'm Rob Myers. I am an attorney, and I am here in support of the substitute bill, which the committee is considering. I'm here for myself, and I'm here by extension on behalf of the tens of thousands of homeowners and small business owners that I have represented in the last 40 years as a property tax lawyer from the taxpayer side. Now, the amendment to the code that is offered, as Judge Keltner said, is very narrow, and it solves a problem that should not have been a problem. In 2009 and in 2019, the legislature saw that the problem for taxpayers who run this administrative gauntlet with the ARB and then in some instances go and appeal values are faced in the very next year with an increase, the same increase that they were fighting the year before. And the legislature changed that and put the burden of proof on the chief appraiser to prove it by clear and convincing evidence, and we thought that solved the problem. The Houston Court of Appeals, however, as Judge Keltner told you, saw otherwise. And in fact, if you've read the opinions, they refused to look at the legislative history, which would have been revealing, and they wanted to see clear, specific language which said that this burden of proof, this enhanced burden of proof applies when we get to the trial court. And the purpose of this bill is to give our friends on the courts of appeals and the Supreme Court the clear and convincing language or the specific language that apparently they feel that they need. It is that simple. Now, let me address a couple of things that my colleague, Ms. Evertson, said. One of the things was, well, gee whiz, we're the appraisal district and, you know, we just don't have the information that we need in order to defend these values. Well, that's a false flag, and here's why. As it relates to this bill, okay, they have been through this process. They have been through this process the year before, either at the administrative level or in a lawsuit. And I can assure you, in the lawsuits that I have tried, there were 21 last year, I think I tried 2 of them. They have the benefit of all of that information. It was discovered in that lawsuit in the year before. And by the way, this is the only circumstance in which this enhanced burden is placed on the appraisal district. It's just when we have done this the year before. That's all. And all we're saying is, look, don't make a taxpayer, don't make a homeowner, don't make a small business person, or for that matter, a large business person, go through this same process every single year. It clogs up our courts. It causes more problems than it solves. At least give us 1 year's breathing room before we have to start this process again, if that's what indeed happens. It really is that simple. It was a problem that we didn't think existed. The Houston Court of Appeals disagreed, and therefore, Chairman Guerin offered this amendment to solve that problem. And it's really that simple. And I'd be happy to answer any questions, of course, that anyone may have.
Members, any questions? Chair recognizes Representative Raymond.
Thank you, Chairman. So I won't ask you to cite all 27, but do you know where this is happening, some areas more than others? Or
Harris County.
it's pretty much Harris?
In my experience, Harris County. That's where my 2 were.
And so
Harris County litigates more than any other appraisal district in the state.
So you worked on 2, but are you familiar with how many others were in Harris County, or you think there were, there were others?
I am certain there were others, many others.
Okay.
Members, anything else? All right. Thank you, sir. Appreciate
I
it.
thank the committee. Thank you.
Thank you, sir. Is there anyone else who wishes to testify on, for, or against House Bill 2488? Seeing none, the chair recognizes Speaker Guerin to close on House Bill 2488.
Thank you, Mr. Chairman and members. And as you've heard from all of the testimony, everybody testified for this bill, no matter how they registered. And I'd be happy to stand for any questions. And otherwise I would close.
Thanks, sir. Committee substitute is withdrawn. If there is no objection, House Bill 2488 will be left pending. Is there objection? Chair hears none. House Bill 2488.
Thank you, Mr. Chairman and members.
Thank you. Show chair button as present.
Yeah. And that's Gio.
Chair lays out House Bill 2482. Chair offers a committee substitute and calls Chair Capriglione to explain the bill.
Thank you, Chairman Meyer. Members, we do have a committee substitute. Thank you for the opportunity to address the committee today. I'm here to speak to you about House Bill 2482, which will help Texas attract and retain co-located data centers. In 2013, the legislature passed House Bill 1223, which implemented a sales tax exemption for data centers to serve as an economic development tool to attract large-scale projects to Texas. Parties must invest $250+ million and build a greater than 100,000 square foot facility to qualify for a sales tax exemption for data center related expenses and equipment such as electricity, IT hardware, and infrastructure. While the bill was successful at bringing some major tenants to Texas, it failed to account for co-location data centers where multiple tenants lease space from one operator. House Bill 2482 modernizes the statutes to ensure that co-location data centers can qualify for the tax exemptions. Texas has had a strong co-location data center market for many years. An economic analysis prepared by Mangum Economics found that existing co-location data centers in Texas generated $1.9 billion in economic output, supported over 4,300 jobs, and generated almost $700 million in state and local taxes in 2022. However, the Texas market is also lagging behind peer markets in terms of growth. Texas markets have grown at only about 5 to 9% per year in the last 5 years, while Northern Virginia and Atlanta have been growing at a rate closer to 25% per year. That is thanks in large part to Virginia and Georgia state legislature that expanded their data center tax credits to include co-location data centers. Our co-located data centers are great for our local economies, workforces, and governments. We cannot keep losing ground. House Bill 2482 modernizes our code to include co-located data centers and updates to ensure that our code keeps up with industry advancements. For instance, many data centers are no longer in one big building, but rather multiple buildings connected via underground fiber cables. These changes will ensure that Texas remains competitive and continues to invest in our innovation economy. Members, I know this bill has a large fiscal note. We have a broad coalition of stakeholders on this bill, and we will work to limit this bill to a point where the fiscal impact is comfortable for members of this committee. I do have some disagreements with the fiscal note, but that all being said, happy to look at ways to limit the bill. I'm happy to take any questions.
Members, any questions? All right, seeing none. Thank you, sir.
Okay, none. Thank you.
Chair calls Kevin Hughes.
Good morning. Thank you, Chairman Meyer and members of the committee. My name is Kevin Hughes, and I am the Vice President of Policy for STACK Infrastructure. STACK is a global data center development company operating in 24 markets, including 10 markets in North America. I am testifying in support of HB 2482. I'm proud to include Plano, Texas on our list of sites where we have data center development today, and we have over 500,000 square feet of space with future room to grow. When I entered the data center industry, it was at an inflection point. For years, data centers were exclusively developed with multiple tenants in mind. But with the introduction of smartphones and the ensuing rise in photos and video content, internet infrastructure evolved. And large tech companies began to build hyperscale facilities that were entirely for their own use. In terms of dollars and scale, those facilities became a majority of the new development prospects. And in 2013, Texas was quick to identify the value and opportunity in competing for those projects and passed legislation exempting sales tax to win those projects. Creating that exemption worked and helped to establish Texas as a major data center market and the only market in North America with a primary market and 2 secondary markets. Nearly a decade later, the industry has continued to evolve. The modern data center market is a diverse, sophisticated ecosystem of new development that includes both multi- and single-tenant facilities to meet today's digital infrastructure demands. This is why HB 2482 is so important. It modernizes the data center sales tax exemption to keep Texas competitive. According to a recent McKinsey analysis, the data center industry is set to double by 2030. In Texas, the question isn't if you will see the data center investment. The question is how much. By including a multi-tenant data center and data centers that connect over private networks, which cannot participate in today's incentive, Texas will be in a position to compete in the modern market. Thank you for your time today, and I'll take any questions.
Thank you, Mr. Hughes. Members, any questions? Very good. Thank you, sir. Chair calls Natalie Stewart.
Good morning. Chairman Meyer and members, my name is Natalie Stewart, and I'm the Senior Vice President of Government and Public Affairs for Switch. And I'm here today speaking in favor of HB 2482. Switch is a large data center operator, owner headquartered in Nevada. We have data center facilities in Nevada, Georgia, and Michigan. And Switch recently acquired Data Foundry, a company with data center facilities in Austin and Houston. Switch provides high-quality, efficient data center locations for over 2,500 customers that range from large household names to small companies. These customers rely on Switch to construct and maintain secure, climate-controlled, efficient facilities capable of handling the IT equipment needed to conduct business. In today's environment, robust, reliable IT infrastructure is critical to an organization's very existence. Unlike a large company that builds and operates its own data center facility, current Texas law prohibits Switch from a sales tax exemption on critical data center components. That is because Switch has multiple customers under one roof or on one campus. I like to paint this picture. Think of it as a mall, right? We have large clients like the UFC and Hulu and Shutterfly in our environment. But you also have your local church and local accounting firm all under one roof. As a result, we are not able to pass the savings along to our smaller customers that the sales tax exemption affords. The Texas current tax climate has not prevented Switch from acquisition and limited development in Texas to serve our customers. However, when we do decide where to deploy our limited capital resources, the tax environment does make a difference. Other states where we currently have campuses provide this multi-tenant sales tax exemption for new large data center construction. HB 2482 by Representative Capriglione helps level the playing field between states and for smaller businesses. This is about equality. The bill makes it much more likely that we will develop large facilities in Texas. I'd like to thank Representative Capriglione for working with the Industry Coalition on this legislation, and we are excited to work with all of you to put Texas back in the driver's seat for data center development. I'm happy to answer any questions.
Very good. Members? Thank you, ma'am. Appreciate your testimony.
Is there anyone else?
Is there anyone else who wishes to testify on, for, or against House Bill 2482? Seeing none, Chair recognizes Chair Capriglione to close on House Bill 2482.
Thank you, Mr. Chairman. Members, thank you for listening to testimony and our layout. I close.
Very good. Thank you, sir. Committee subs.
I have a question.
Oh, I'm sorry. Chair. Chair recognizes Chair Button.
Close. Okay.
Chairman, I just want to conclude my observation. So you're talking about, earlier you mentioned the fiscal note, okay? But this is not just, it's not a expense. It's not if we call it expenditures, actually it is an investment for the future of Texas in order to continue to recruit and maintain this kind of data center coming to Texas. Is that correct? Is my observation correct?
You're right, and thanks for bringing that up. If you look at the other incentives that we've provided in this space, now not on the data co-location, but on just the main data centers, we've seen over $1.9 billion in economic impact. We've seen revenue increasing overall, both state and local, obviously new jobs. I mean, if you look at some of the most valuable things, there are gold, Texas has it, oil, Texas has it, but data is both the next oil and the next gold. So this gives us an opportunity to not only grow, keep what we got, but grow what we have.
Thank you very much.
All right, thank you.
Thank you. Very good. Thanks, sir. All right, committee substitute is withdrawn. If there's no objection, House Bill 2482 will be left pending. Is there objection? Chair hears none. House Bill 2482 is left pending. Show Representative Munoz as being present and show Vice Chair Theory as present as well.
Okay.
Chair lays out House Bill 2908 and calls Chair Murr to explain the bill.
Good morning, Your Honor. May it please the court. This bill is not about burdens of proof. So thank you for the opportunity to lay out House Bill 2908 before you today. Very simply, this bill adds provisions to the tax code that would allow appraisal districts to incur debt in order to finance the purchase or construction of facilities. Now, right now, an appraisal district has the same purchasing and contracting authority that a city does under the local government code. But what is not clear is, does it have the ability to borrow funds? And so what is actually going on in the industry is your appraisal districts, lacking that clear conciseness in state law, they create shell corporations to finance their construction projects and then do a lease back to the appraisal district. And then once that lease back term is expired, then the shell corporation goes away. And I bring this up because that is the method that is currently being used around the state of Texas. In my home county, in our appraisal district, actually entertained the idea of buying an old bank building. An old bank building had teller windows, it had a vault, it had a meeting place for the board, had plenty of office space. It was great. But they didn't have it in their budget to be able to purchase that outright. They would have had to finance it. But the code is not clear on that. And so the only direction or guidance that they received was to create a shell corporation and do that. Well, the local entities and the officers that are on that board all said, no, we're not going to create a shell corporation. And so they didn't go down that route, and they didn't choose the best location for the appraisal district to be. So the goal here is simply to increase transparency and make it very clear that our appraisal districts have the same authority that municipalities do. And Mr. Chairman, I'm happy to answer any questions if there are.
Very good. Members, any questions? Oh, we've got a couple. Representative Raymond and then Representative Shine.
Thank you, Chairman. Who tried to create a shell corporation?
I believe you might hear testimony that does occur from time to time. At local level,
No, yeah,
that was considered, but it was declined.
In this case, I mean, in your case, and if you don't know, that's okay, but do you know, like, who was trying to do that?
No one was trying to do that. That was the advice that was provided to the appraisal district that said, really, the only way under Texas law for you to successfully borrow money to buy this building is for you, the appraisal district, to create a shell corporation, have that shell corporation acquire the building, and then you lease it from the shell corporation. Because you can.
Maybe I should be asking who is advising them that.
And so that appears to be somewhat common practice around the state as the only way, because they do have the power to purchase and the power to lease. And so our issues with it locally were it just wasn't on the up and up, and no one wanted to go down that road. And so they didn't. And so I sat down with our chief appraiser and sat down with others that are on the board, and they said, sure wish the law was clear cut here so we could simply do what folks expect us to do, which is if we were going to borrow money and we think that's the best move, then we do that and everybody knows what we're doing.
So what facility do they have now? Some old building? Have they had it some time? Or in your case?
Succinctly, they were located in the courthouse.
Okay.
Free. The courthouse is going through a courthouse restoration grant process, so everybody's eventually moved out of the courthouse, so they have now rented some space nearby. It is satisfactory, but it is not the equivalent of where they could have been.
Right. Thank you.
Chair recognizes Representative Shine.
Representative Murr, is this to let them go out and borrow money by a debt issue or something like that, or is it, what's the process? I mean,
no.
If they are, okay. Because if that was the case, I'd be curious as to what type of bonds that they would want to be issuing.
No, we're not. This isn't about issuing bonds. This is about an ability to go finance the purchase of a building.
Borrow the money from the bank.
Yes.
And require the taxing entities that fund the appraisal district to provide the monies for them to pay it back. Is that right?
In essence, but it also requires their approval. It's not something that the appraisal board could do without the authority of the taxing entities.
But if they approve, then
yes,
the taxing entities would have to make sure the budget had enough money to make the purchase.
That is correct. Yes, sir.
Thank you.
just like they do right now with a lease. Thank you.
Members, any other questions? All right, very good. Thank you, sir. Chair calls Brent South.
Good morning, Mr. Chairman, members of the committee. My name is Brent South. I'm here representing the Texas Association of Appraisal Districts, and we are in support of House Bill 2908. I would like to thank Representative Murr for filing this very important bill. He did a great job on the layout. This basically brings transparency to the process. Right now, Appraisal District Board of Directors, if the appraisal district needs a new facility or an addition to an existing facility, they are currently having to go out and establish and create these shell corporations to borrow the money. They lease the building back to the appraisal district. At the end of the lease, which is usually the same term as the financing, they sell it back to the appraisal district for $1 and dissolve the corporation. And that's just not a great way to, it's not a very transparent way for property tax money to be utilized. So we feel this brings great transparency to that process. The taxing units, Representative Shine, to answer your question, the taxing units still have to approve that part of it. They still approve the appraisal district's budget annually. So there's no difference on the approval process. So it still does have to go before those taxing units, before that money can be borrowed. Be happy to answer questions.
Very good. Members, any questions? Chair recognizes Representative Munoz.
Do you know how many of those shell corporations were created? And what
I don't know a number. We could probably track that down for you, but I do know it has occurred. I know I can think of 4 or 5 off the top of my head, but I don't know the exact total.
Those 4 or 5 would be where?
Well, I know that it's happened in, I believe, Harris County, Travis County. I think that Rockwall County had to go through that recently. And there was a couple that, and I think there's a couple that decided we're not going to do that. But I can get you a full list of where it has occurred.
All right, thank you.
Sure.
Thank you, Mr. Chairman.
Thank you, members. Anything else? Thank you, Mr. South. Is there anyone else who wishes to testify on, for, or against House Bill 2908? Seeing none, the chair recognizes Chair Murr to close on House Bill 2908.
Thank you, Mr. Chairman, committee members. I appreciate the time to visit with you. If you have any questions, let me know. Otherwise, I appreciate your favorable consideration on this legislation.
Thank you. If there's no objection, House Bill 2908 will be left pending. Is there objection? Chair hears none. House Bill 2908 is left pending. The chair lays out House Bill 2121 and calls on Representative Paul to explain the bill.
Thank you, Mr. Chairman. Members, it's got a nice little bill here. Maybe y'all will be able to hear it, vote it out, and be done with it real quick. But this is a bill for small business owners, such as myself, where we have to file every year a business personal property tax for our companies. It shows vehicles you might own or what you might use, property like desks, computers, and all that kind of stuff. So if you're a small business owner, we're filing this each time. And you have to actually have this form notarized before you could send it in. I guess they want to make sure that we're telling the truth about what it is. But when you're talking about such a small burden that we really felt, let's help out these small businesses. Don't force them to have to go through this. I know a lot of companies have notary in their company. Small businesses don't. They got to go pay somebody or go track somebody down. Then their form's late. So this bill makes it simplified that if you're less than $500,000, that we'll take your word for it and approve what you're doing. Still have to send in the form, still have to send in and tell them what we have. We'll still be taxed. We just don't want to make them required to do this for such a small amount.
Very good. Members, any questions? Chair recognizes Representative Raymond.
Thank you, Chairman. I want to work with you on this. Would you be open to an amendment, say not more than $5 million?
Sounds good to me, Chairman. Just so I don't have anything to do with funeral parlors.
All right, members, any other questions? Yeah, all right, Representative Paul, hold on real quick. Is there anyone who wishes to testify on, for, or against House Bill 2121? Seeing none, the chair recognizes Representative Paul to close on House Bill 2121.
All right, with that, no other questions, I'll close.
Very good, thank you, sir.
Thank y'all.
If there's no objection, House Bill 2121 will be left pending. Is there objection? Chair hears none. House Bill 2121 is left pending. Chair lays out House Bill 3651 and calls on Representative Bales to explain the bill.
Chairman Meyer, committee appreciate the opportunity to lay out House Bill 3651. Current law lacks the clarity, the specific definitions to ensure successful prosecution of individuals who unlawfully or fraudulently acquire motor fuels. Motor fuel theft schemes often involve stolen credit card data, which the state law also lacks provisions tying motor fuel tax crimes to unauthorized use of credit cards or money. For example, some motor fuel theft schemes involve the use of clone cards, which are fraudulent cards, which are re-encoded with stolen credit card, debit card data to illegally purchase hundreds of gallons of gas or diesel fuel. House Bill 3561 gives prosecutors another tool to fight these crimes. In addition to credit card skimming tied to motor fuel tax and theft fraud, other creative schemes to fraudulently acquire motor fuels and evade the tax fall outside the existing definition, and they evolve faster than state law can keep up. For example, criminal suspects have used modified passenger vehicles like trucks, box trucks, minivans, or sport utility vehicles to steal gas and diesel to deliver the semi-trucks or other, despite the clear purpose of modifying these vehicles to steal motor fuel and resell it for profit. It falls outside of the current definition of transport vehicle for purpose of motor fuel tax fraud. Because the strict definition in current law failed to capture these new and evolving schemes, prosecutors have declined to prosecute some of these cases based on the low likelihood of securing a conviction. House Bill 3561 amends the tax code to revise certain definitions and add provisions relating to motor fuel tax regulation to strengthen the Comptroller of Public Accounts, Criminal Investigative Division, and their ability to investigate these crimes. We have resource witnesses who are best suited to answer any questions, and I reserve the right to close.
Very good.
Mr. Chairman.
Yes, sir. And for clarification, this is House Bill 3651, I believe, correct?
Correct.
Okay, very good. Members, any questions? Anybody? Is there anyone who wishes to testify on, for, or against House Bill 3651? Seeing none, the chair recognizes Representative Bales to close on House Bill 3651.
Chairman, I close.
Very good. Thank you, sir. If there's no objection, House Bill 3651 will be left pending. Is there objection? Chair hears none. House Bill 3651 is left pending. Chair lays out House Bill 3325 and calls on Representative Goodwin to explain the bill.
Thank you. Good morning, Chairman and members. As Texans move further into the 21st century, they expect their government to modernize as well. Our statute requires appraisal districts to notify property owners they might be eligible for a residential homestead exemption and also provide a homestead application form by mail. We certainly want to notify property owners they are eligible for a residential homestead exemption. Homestead exemptions offer homeowners valuable property tax relief that can help homeowners afford to stay in their homes and remain financially stable. These exemptions are especially valuable as home valuations rise across the state. However, we don't have to send everyone a clunky application form when so many would prefer to fill out an online application. House Bill 3325 allows appraisal districts the choice to provide notification that provides an online application option for a homestead exemption or provides instructions for how to receive a paper application. Without this law, appraisal districts will continue sending a paper form to identify property owners that may be eligible for a residential homestead exemption. If appraisal districts offer an online option, the notice must contain a description of the procedure for applying for the exemption online, an internet address at which to complete the form, and a statement that the owner may receive the form by mail on request or at the appraisal office. If the appraiser receives a request for a form, they must provide the form by regular mail or in person at the appraisal office. There are many benefits to this modern option. At the top of the list, it reduces errors. It saves some poor souls in tax offices the trouble of deciphering poor handwriting and correctly transcribing it. And it ensures that all the required paperwork is attached to complete the application. This saves time for the tax office, and it saves confusion on the part of a homeowner who filed an application but missed the notice that their incomplete application was missing paperwork and therefore did not receive the exemption. It also saves money. The cost of printing and mailing forms adds up, as does the time to manually enter returned paperwork and reach out to applicants that didn't provide all the paperwork. Many people in this modern age expect an online option, and this bill will enable that option. However, I also recognize that in many parts of Texas, internet access isn't readily available. So this law is written to give tax appraisal districts the option to offer an online option. If the appraisal district doesn't offer the online option, they must continue to mail the homestead exemption application form. Local districts know their capabilities and the preferences of their community. Mr. Chairman, thank you for hearing this bill today. I'm happy to take any questions, and there is a witness who can speak to how this law would help them as a tax assessor.
Very good. Thank you, Representative. Members, any questions? All right, seeing none. Thank you, ma'am. Chair calls Maria Krigler.
Thank you, Chairman, members of the committee. My name is Maria Krigler. I'm the Chief Appraiser of Travis Central Appraisal District. I'm here representing the Texas Association of Appraisal Districts, and we are here in support of the bill. I really appreciate Representative Goodwin's filing the bill. For us, the number one reason why we have to deny any homestead application is because the property owner failed to include the required documents, which is a copy of their driver's license or Texas ID, and the address has to match. And that is when they file their applications by paper. However, we have an online opportunity for them to file their application online. And when we would do that, we have a process that steps them through to include prompts for them to upload their documents. So when they file online, I have 0 denials because we didn't get the appropriate documentation. So we think it is really beneficial to the property owners. It helps them step them through the process and ensures that they submit everything required to get approved for their homestead exemption. So we strongly approve and support this bill. With that, I'm happy to answer any questions.
Very good. Members, any questions? Thank you, Ms. Krigler. Appreciate it. Anyone else? Is there anyone else who wishes to testify on, for, or against House Bill 3325? Seeing none, the chair recognizes Representative Goodwin to close on House Bill 3325.
Thank you, Chairman and members. This is a bill that would simply allow people an easier option to submit their homestead exemption application online, and I hope you'll give it favorable consideration.
Thank you, Representative. If there is no objection, House Bill 3325 will be left pending. Is there objection? Chair hears none. House Bill 3325 is left pending. Chair lays out House Bill 3555 and calls on Representative Plaza to explain the bill.
Thank you, Chair Meyer, Vice Chair Theory, and members for allowing me to lay out House Bill 3555 for you all today. House Bill 3555 provides for more transparency in taxation and is called taxparency. As property values continue to rise, so do property tax bills. The city and the county can adjust their tax rates accordingly, but the school district's revenue is tied closely to state funding and does not have that flexibility. Texas homeowners know that their property taxes contribute to public school funding and assume that as they pay more in property taxes, this means more money goes to local schools and their districts. But as all you know, that may not always be the case. House Bill 3555 remedies this confusion by making clear to the property taxpayer how much of their tax bill will remain in the local school district. All of us are committed to providing property tax relief and making sure we have great school finance in Texas. This bill, unfortunately, does not touch property tax relief or school finance, but it is a step in the right direction, bringing transparency to taxation. Last session, Chairman Meyer did a lot of great work to further transparency and passed a bill with Senator Bettencourt. We would like to build upon that and help our school districts out with some added transparency on each tax bill. Thank you for listening today. I have a few witnesses here who can elaborate and answer any questions. And with that, I reserve my right to close.
Very good. Thank you, Representative. Members, any questions? All right, thank you. Chair calls Nancy Humphrey.
She's on her way.
Okay, the chair will wait to call Nancy Humphrey and instead call, oh, she's coming up. Okay, chair then definitely calls Nancy Humphrey.
Sorry about that.
Fine.
Trying to get my piece of paper.
Oh, you're fine.
All right. Good afternoon, Mr. Chairman and committee members. Appreciate you giving us the opportunity to speak in favor of House Bill 3555 today. This bill addresses what we call taxparency, and that's a grassroots effort that, sorry, I'm out of breath, just walked over here, started in Plano ISD, aimed at promoting transparency regarding how taxpayers' dollars are being spent on public education. Currently, tax statements do not provide any transparency regarding taxpayers' local dollars that are sent back to the state as required by Chapter 48 of the Education Code. We've been working since 2017 to support the passage of this legislation that would require property taxes to fully disclose how tax dollars are being collected. In Plano ISD, more than a third of school district tax amount collected from taxpayers goes to the state in the form of excess local revenue. And for the average taxpayer in Plano ISD, the excess local revenue portion of their tax bill exceeds their city portion. Many taxpayers don't realize that when their property taxes increase due to a rise in property value, the school district's operating budget does not increase in the same manner as it does in the city, the county, or the college district. Taxpayers have a right to transparency in knowing how their property tax dollars are collected and spent. A portion of their local property tax collected by school districts is paid to the state. The state uses these funds in its budget, and there's no transparency to the taxpayers. As these payments continue to grow, school districts may be forced to adopt deficit budgets, yet taxpayers' bills continue to rise due to increased property values. As a result, there's a disconnect between taxpayers, what they pay in school district tax, and what they believe their local school district has available for its budget, which in fact is shrinking due to reduced buying power brought on by inflation and no increase in the basic allotment. There's no recourse for citizens who want to take issue with the amount of their property tax bill because they're not made aware of it. As public officials, we owe it to those whom we represent to be transparent when collecting their hard-earned property taxes. It's disingenuous to collect property taxes under the name of a school district that will never benefit from these tax dollars. Taxpayers deserve to know where a large chunk of their dollars are being spent when it's collected and remitted back to the state as excess local revenue. When taxpayers understand how their taxes are being collected and used, they are more likely to have confidence in the government's ability to manage public funds. They'll be more likely to believe they are being treated fairly and more likely to believe that the tax assessment process is objective and impartial. So thank you very much for letting me speak. Are there any questions from me?
Members, any questions?
Mr. Chairman.
Oh, yes, Chair recognizes Representative Noble.
Thank you, Mr. Chairman. I'm so happy to see you here today. We've talked about this for a lot of years.
Right.
There's quite a few school districts that this would affect. More than 250 school districts in the state are under recapture. What do you think that would look like on a tax bill? How do you anticipate that? How would that be broken out?
Okay, well, Representative Place's bill just shows that it would be the percentage spent or the taxpayer's tax, the percentage that stays within the school district and the percentage that goes back to the state. So it's not meant to be divisive. It's just transparency, plain and simple, so the taxpayers know.
Great, thank you.
You're
Thanks for being
welcome.
here today.
Thank you.
Very good. Thank you, ma'am. Chair calls Chandra Villanueva.
Committee Chairman, my name is Chandra Villanueva. I'm with Every Texan, and I'm testifying on the bill. School finance is very, very complex, and this bill doesn't provide enough context around why we have recapture and why it's been growing. Just for instance, charter schools are one of the large reasons why we are seeing increases in recapture. When we lose a student to a charter school from a traditional ISD, that pushes districts closer to recapture, and it increases recapture for districts already paying. And this bill doesn't have anything that includes how much of your local recapture dollars are staying within your community to fund the charters within that area. Also, there's a lot of more context around school finance. There should also be maybe a disclaimer that says the basic allotment is a completely arbitrary number based on absolutely nothing and is not adjusted for inflation. Yet another reason why recapture continues to grow every single year. So I just have concerns that this bill will create just sort of undue criticisms around the recapture system and take the focus off of what we really should be focusing on, which is fully funding our public education system.
And for clarification, you are neutral on that?
I am neutral,
Okay.
yes.
Very good. Members, any questions? Thank you, ma'am. Appreciate it.
Thank you.
Kevin Kieschnick.
All right, we'll try it. Kevin Kieschnick?
Good afternoon, Chairman Myers and committee. Kevin Kieschnick, Nueces County Tax Assessor Collector, also here representing Tax Assessor Collector Association of Texas. And we are neutral on the bill. We just have a couple of recommendations for the bill, which we have communicated with the bill author. And those concerns really just lie around how much more complicated we'd be making the property tax statement itself and who would be getting that information. First, on the complications, we try to keep these tax bills as precise as possible because they have very specific information and it's standardized across how much you're paying, and that seems to be what most people are most concerned with by the time they get their tax bill. Secondarily, we look at issues around who receives the tax bill. Talking to one of my counterparts, Larry Gaddis in Williamson County, and then of course Nueces County, we have in Nueces County about 49,000 people who won't get that bill because their homes are mortgaged. That tax bill goes to the mortgage company. In Williamson County, it's around 100,000 people who won't receive that bill because that goes to the mortgage company. The bills go to the place where the person pays the taxes because we don't want to be sending out multiple bills and then having people confused of who's paying what and those sort of things. So it's pretty common across the state, and that's just 2 counties within the 254. So I would say you could probably extrapolate that out, that the number of people who would not receive the information might be well over 1 million plus statewide because of that. And so really what our recommendation is that we place this information, it's pretty complex as well. We place this information on a website where they can actively go out and retrieve that information because, like, for instance, my kids go to Calallen ISD, and if I was curious about that, I would be looking to the school district to provide that information. We think that's just a better home for this information. We're not opposed to putting this information out there on the bill, and that's why we're not placing a position on it, but we do think that there are better places for that to be where it's more readily accessible because, quite frankly, people get their tax bill, they pay it, and they throw it away. And so that's about all I have. Very happy to entertain any questions.
I had a question.
Chair recognizes Vice Chair Theory.
Thank you, Mr. Chair. Are you saying that the information is currently on these websites?
No, what we're saying is that'd be the best place to put this information. Now, it could be on some districts' websites. I'm not sure. There's nothing that prevents them from doing so. We're all about being transparent and getting that information out there. But there's just a better place for that, and we believe that would be on the website.
Okay, but as of now, it's nowhere.
I wouldn't say nowhere. I'm sure some districts may have it out there, but there's not a uniformity to it.
Okay, thank you.
And, so I think the idea is great, but we need to, kind of put this in places where people can find it, where they would naturally go to look for it.
Are you saying they wouldn't find it on their tax bill?
Well, it would further complicate it. And I think probably a good example of that would be, have you seen a cell phone bill lately? I mean, you look at pay and it's got 5-10 pages of stuff on there that nobody reads. And we already find that with the tax bills themselves, because half the time when people come to pay their taxes at our office, they bring me their notice of appraised value, which is not their tax bill. So half of them, that tells me they're not really looking at these things real close, especially when your notice of appraisal says this is not a bill, but they're still bringing that to pay their taxes with. And the other half of them don't even have their tax bill with them. They don't know where they've misplaced it. They're not sure where it's at. So this information is quite complex, especially when you get into school finance. And I think it really requires a lot of very specific information specific to the school district that they could provide. And I think the district's website would be the best place for that.
Would you be open to putting a statement on the bill that directs them somewhere to find it?
We could put it, I don't know that people will read it. And remember that you got about 150,000 people between our two counties alone that don't even get that bill.
But we have to hope people are reading something on it. That's why we mail it.
Well, there's 150,000 people who don't get that bill. So you're looking at 1 million plus who aren't going to get that. I mean, we could put the link on there or something. I mean, we're amicable to talking about this bill. We're not obviously not against this bill. I think the idea is quite firm, but putting that complex information on the tax bill, people aren't going to look at it.
Okay, thank you.
Thank you.
Members, any other questions? Thank you, sir. Appreciate it.
All right, thank you.
Anyone else? Yeah, Christie. Sorry. Chair calls Christie Rowe.
Hello, Mr. Chairman and members of the committee. My name is Christy Rome, and I'm here to testify in favor of House Bill 3555 on behalf of the Texas School Coalition. And you've already heard from Ms. Humphrey today that we refer to this concept as taxparency because we believe this is important information to put in the hands of taxpayers. Many people don't understand that the tax payment that they are paying to their local school district doesn't always necessarily stay in and benefit that local school district. So we believe this is important information to give to the taxpayers. It's also beneficial to districts that are not paying recapture because it explains the share of funding that comes from the state to fund that local school district and the share that comes from local taxpayers. It's just, again, information. We believe it's important information to put on the property tax bill because that is where people look to for their information on their property taxes. But it would be a great addition to the property tax website as well. We just really think it's important to get that information out there. And I will note that one challenge of property tax relief is making that relief apparent to the taxpayer. And this taxparency measure also helps to provide information in that regard, so that as legislators continue to provide property tax relief, the taxpayer will see a greater percentage of their payment staying in their local school district. So I'm happy to answer any questions you may have and appreciate you hearing this bill today.
Very good. Thank you, Ms. Rome. Members, any questions? Very good. Thank you.
Anyone else?
Is there anyone else who wishes to testify on, for, or against House Bill 3555? Seeing none, Chair recognizes Representative Plaza to close on House Bill 3555.
Thank you, Chairman and committee members, for allowing me to lay out this bill. As you see, this is a very important bill to my district, and I just want to thank everybody that came out and testified. Just for clarification, this bill is not about complicating anything. This is about clarifying things. This isn't about charter schools or recapture. This is just showing the people of Texas the receipts. We've done a lot to fund public education in the state of Texas with the passage of HB 3. We're just building on what your work has done in this legislature. And just to let everybody know, not everybody gets on these websites. Not everybody is tech friendly. Not everybody knows to go and look at this. But my districts, they read their property tax bills. They read that stuff front, back, left, and right. And so this would be very beneficial to show the people of Texas the hard work that we have been doing to fund public education. So with that, I'll answer any questions and reserve my right to close.
Very good. Members? And with that, you close, Representative? And with that, you close?
Yes, sir.
Very good. Thank you.
Thank you.
If there's no objection, House Bill 3555 will be left pending. Is there objection? Chair hears none. House Bill 3555 is left pending.
Go back that way to 640. That's it. Okay, there you go.
Chair lays out House Bill 640 and calls on Representative Johnson to explain the bill.
Thank you, Chairman Meyer and committee members. Appreciate the opportunity to talk to you today about House Bill 640. This bill addresses two important issues relating to the use of the street maintenance and repair sales tax. The SMR is a special sales tax in the tax code used by some cities to repair streets and sidewalks. Otherwise, these cities would not have the funds to maintain these important components for mobility and infrastructure in our communities. Under current law, the street maintenance repair tax expires for most cities 4 years after it was approved by the voters, unless voters reauthorize the continued collection of the tax in an election. There are exemptions for certain cities under the current statute that allows for reauthorization every 8 to 10 years instead of 4. House Bill 640 will make this reauthorization period of 8 or 10 years available to all cities that utilize street maintenance taxes, so long as the other criteria under current law is also satisfied. This criteria includes approval by a majority of the voters voting in each of the last 2 consecutive elections concerning the adoption or reauthorization of the street maintenance tax. House Bill 640 will allow proceeds from the street maintenance tax to be used to maintain or repair streets and sidewalks or water, sanitary sewer, and stormwater drainage infrastructure when it is associated with the repair, maintenance, and reconstruction of a municipal roadway. I believe we have a witness, and I'll reserve my right to close.
Thank you, Representative. Members, any questions?
Thank you.
Very good, thank you. Chair calls Wes Mays.
Chairman Meyer and members of the committee, thank you for the opportunity to speak in support of House Bill 640. My name is Wes Mays, and I have the honor of serving the citizens of Coppell as their mayor since 2021, and I've been on city council since 2012. And I'd like to thank Representative Johnson for sponsoring this bill. Our city council has a legacy of long-term planning with a focus on keeping the priorities of our citizen at eye, and also a very keen eye on our budget. Since 2015, the city spent approximately $36 million on 2 roadway projects that carry significant pass-through traffic during peak hours due to our strategic location. Over the next 5 years, our city council will be considering over $65 million of potential projects to rebuild our aging neighborhood streets. The utilization of Chapter 327 is an important tool in helping our city council address Coppell's aging streets and roads. Our previous elections have shown overwhelming support from our citizens in reauthorizing the quarter-cent sales tax. For example, in 2007, Chapter 327 was approved by 63% of our voters. When it was reauthorized in 2011, it was approved by 72%, in 2015 by 83%, in 2019 by 76%, and most recently in 2022, it was approved by 81% of the voters. We believe that we have compelling reasons to request that the citizens of Coppell be allowed to reauthorize the street maintenance tax on a 10-year basis from the current limitation of 4 years. While we absolutely value the input of our citizens during the concept phase of our project, this does cause the schedule to be longer. For example, a recent project took approximately 6 years from concept to completion. The Coppell City Council supports House Bill 640, amending Chapter 327 from its current 4-year term to a 10-year term. Extending the time will provide the council and our citizens more certainty in planning and funding much-needed street maintenance. Mr. Chairman and members of the committee, thank you very much for the opportunity to speak in support of House Bill 640. Thank you.
Thank you, Mayor. Members, any questions? Very good. Thank you, sir.
Thank you.
Is there anyone else who wishes to testify on, for, or against House Bill 640? If not, the chair recognizes Representative Johnson to close on House Bill 640.
Thank you, Mr. Chairman. I think this just gives the city a little bit more flexibility to finance the debt over a longer term than the 4 years. That will give them a lot more flexibility. With that, I close.
Very good. Thank you, Representative. If there's no objection, House Bill 640 will be left pending. Is there objection? Chair hears none. House Bill 640 is left pending. Chair lays out House Bill 3358 and calls on Chair Button to explain the bill.
Thank you, Mr. Chairman. Members, as part of an effort to increase access to broadband internet, the legislature passed HB 1133 back in 2013, authorizing a sales and use tax refund for property used in connection with improving the cable TV services, internet access service, or telecommunication services. The maximum amount that can be provided is currently capped, and the capped amount is prorated among all providers. While this effort has been successful, the pandemic underscored the need to ensure high-speed internet was available in every corner of our state in order to work, learn, and access essential services. Additionally, with the one-time infusion of federal dollars for infrastructure projects, the time to maximize private sector investment for affordable, high-speed broadband access is right now. HB 3358 aims to advance these efforts by temporarily removing the sales tax rebate cap, allowing such refunds to equal the amount of applicable taxes paid from year 2024 until the end of 2029. And I have a few witnesses here, and I reserve the right to close.
Thank you, Chair Button. Members, any questions? Very good. Thank you. Jerry Keegan. Chair calls Jerry Keegan.
Chair, members of the committee, Jerry Keegan with CTIA, the trade association for the wireless industry, here in support of this legislation. Almost a decade ago, this legislature had the foresight to create the state sales tax rebate program for equipment that went into communications networks. Now that the federal government is about to provide once-in-a-generation broadband funding, Texas has a unique opportunity to allow for all of that funding to be invested in broadband networks. Furthermore, because of the federal funds are going to be targeted to unserved or underserved areas of the state, the residents and businesses in those areas of the state will benefit the most from this legislation. This legislation will allow the companies investing in Texas to put all of their investment into their broadband networks. We all know that investments in broadband infrastructure is just as important as investments in other infrastructure, whether that be roadways or highways. As the wireless industry continues to deploy 5G technology throughout the state, this legislation will ensure for certainty when it comes to capital investment planning. Texas has become an economic powerhouse, and you've done so by enacting pro-investment tax policy that creates an economic climate that supports growth and job creation. As Texas continues to compete to attract growth and technology firms, this legislation will provide the communications infrastructures to support that growth. For these reasons, we strongly support this legislation. Thank you for your consideration.
Very good. Thank you, sir. Members, any questions? All right, thank you. Chair calls Walt Baum.
Thank you, Mr. Chairman. Members, my name is Walt Baum, and I'm president of Texas Cable Association, and we're here today testifying for House Bill 3358. Our 5 cable company members serve over 1,000 communities in Texas. We've got over 4.5 million broadband subscribers and over 18,500 employees working in the state. It's crucial for all Texans to have access to robust broadband internet in order to fully participate in the modern economy and society, including in areas such as education, healthcare, and remote workforce. Despite significant private investment in broadband infrastructure, there is still a need for public investment to ensure that all consumers have access to high-speed internet, especially in less populated non-metro areas. Deploying and maintaining this infrastructure is costly and every dollar counts. By temporarily removing this sales tax cap rebate, Texas can incentivize private sector investment in broadband infrastructure. So our industry is different from a lot of industries. Before coming over and working cable broadband issues, I represented the electric industry for over 20 years. And I was surprised when I looked at the differences in tax. I mean, we currently, You know, imagine if your furniture store had to pay sales tax when it bought a table from a manufacturer and then collect tax again when they sold it to you. But that's the same system our industry faces. We buy coax, we buy fiber, we buy routers, we buy electricity, we buy software, 1,000 other items every year to provide broadband and communications and cable, and we provide tax on virtually all of it. And then we collect sales tax again on our services. It's a double tax system without real justification, and this bill would eliminate that double tax at least temporarily. The next several years, as Representative Button said, the next several years will be crucial in the effort to get broadband built out to all corners of Texans, especially with all of the federal money coming down. Increasing this rebate for a limited time will help us maximize this once-in-a-generation infusion of federal funds. And in conclusion, we urge the passages of this bill, and I'm happy to answer any questions.
Very good. Thank you, sir. Members, any questions? Very good. Thank you, Mr. Baum. Is there anyone else who wishes to testify on, for, or against House Bill 3358? Seeing none, the chair recognizes Chair Button to close on House Bill 3358.
Thank you, Mr. Chairman. Members, as all the witnesses have emphasized, the importance of invest for the future in the infrastructure area is actually the basis for the investing the future for our entire state. So I humbly ask for your favorable consideration. I close.
Thank you, Chair Button. If there's no objection, House Bill 3358 will be left pending. Is there objection? Chair hears none. House Bill 3358 is left pending.
4101, I think is the sign.
Is he ready?
I believe so.
Hugh. You ready? Chair lays out House Bill 4101. Chair offers a committee substitute and calls Representative Shine to explain the bill.
Thank you, Mr. Chairman and members. I have a committee substitute, and as y'all know, we've spent a lot of time in our office working with property owners, different tax officials, to find ways to address the issues associated with our property tax system in Texas. Last session, House Bill 988 established the ability for property owners to access limited binding arbitration to compel the Appraisal Review Board to comply with certain procedural requirements. Some of these things we've already discussed, even in some other legislation today. That when a property owner feels a particular requirement hasn't been followed. Since the process, it's been successful, so we've looked at other situations where property owners might have issues where limited binding arbitration could be a remedy instead of other more costly and burdensome methods. So House Bill 4101 would set out 3 new opportunities for property owners to assess limited binding arbitration. So we will hear from some stakeholders and the Comptroller's Office who think some of the additions the filed bill was making might have caused some unforeseen issues. So we looked at this, and with the substitute, we have addressed those concerns. And as substituted, we'll have opportunities here to look at the Appraisal Review Board and the binding arbitration with what the substitute does. It drops it from 3 to 1. And I believe there's some witnesses as well, reserved the right to close.
Very good. Thank you, Representative. Members, any questions? Chair calls Ray Head.
Good morning, Mr. Chairman and members. My name is Ray Head, and I'm here on behalf of the Texas Association of Property Tax Professionals to speak for HB 4101. In the 87th legislature, House Bill 988 passed, which among other things required CADs and ARBs to comply with adopted hearing procedural rules. And it provided owners the right to file for limited binding arbitration when they believe a certain procedural requirement had not been complied with in a formal hearing. House Bill 4101 expands the scope of hearing procedural requirements that must be complied with in the order to file for limited binding arbitration. In filing for limited binding arbitration, the property owner and the CAD also have a 10-day window in which to address a complaint and resolve any issue or issues the property owner alleges they have not been complied with. And this process has been very successful in resolving complaints and grievances filed by owners, and HB 4101 will make the property tax system more efficient, more cost-effective when compared to filing suit to compel compliance, and it ensures property owners have a meaningful avenue to a fair, formal appeal hearing when a procedural right has not been complied with. HB 4101 has been reviewed by stakeholders to include the Comptroller's Office and the Texas Association of Appraisal Districts. The substitute addresses the concerns that were raised, and we are in agreement with those changes. And I'll be glad to answer any questions I can.
Members, any questions? Very good. Thank you, sir.
Thank you, Mr. Chairman.
Chair calls Brent South.
Good afternoon, Brent South, Texas Association of Appraisal Districts. We're testifying on House Bill 4101. I just wanted to say that we originally were opposed to the expansion of the limited binding arbitration, but thanks to all the work from Representative Shine and his staff and the other stakeholders, we're now at a point where we feel comfortable. The bill as substituted would increase the limited binding arbitration to ensure that appraisal review boards are following the model ARB hearing procedures prescribed as set out by the Comptroller's Office. We feel that makes sense. ARBs should be following those procedures, and if they're not, I think that a property owner does have the right to be able to have some type of challenge against that. So we're not fully to supporting the bill. We are definitely at a neutral point, and again, wanted to thank Representative Shine for working with us on that. Happy to answer questions.
Very good. Thank you, Mr. South. Members, any questions? Thanks, sir. Chair calls Paul Pennington.
Thank you, Mr. Chairman. Appreciate the opportunity to be here today. My name is Paul Pennington. I'm from Carrollton, Texas. I'm the co-founder of Citizens for Appraisal Reform. We strongly support HB 4101. We strongly support the notion that an appraisal review board has to follow the model hearing procedures prescribed by the Comptroller. We think all stakeholders and all professionals in this field would get behind that notion to have a fair hearing for tax bills. Based on that, we strongly support it, and we would urge passage of this bill. Thank you.
Thanks, sir. Members, any questions? All right, thank you. Is there anyone else who wishes to testify on, for, or against House Bill 4101? Seeing none, the chair recognizes Representative Shine to close on House Bill 4101.
So, Mr. Chairman and members, whole purpose again in this process is to put as many tools as possible in the hands of the people that pay the bills for the state of Texas. That's the property taxpayers. And procedures are important. And if the procedures are not being followed by the institutions that are there, the property taxpayers should have a method of grievance that they can pursue to take care of that. And that's what House Bill 4101 does.
Very good. Thank you, Representative. Members, any questions? All right, thanks, sir.
Thank you, sir.
The committee substitute is withdrawn. If there is no objection, House Bill 4101 will be left pending. Is there objection? Chair hears none. House Bill 4101 is left pending. Chair lays out House Bill 4181 and calls on Representative Munoz to explain the bill.
Thank you, Mr. Chairman and members, for allowing me to present House Bill 4181, which is entitled the Veteran Spouse Residential Homestead Legislation. House Bill 4181 would look at expanding the current homestead exemption of a surviving spouse to include a surviving spouse of a National Guard dual service technician. In current statute, resident homestead exemptions only apply to surviving spouses of U.S. military service members who are killed or fatally injured performing federal duties. Currently, in the last couple of years, Texas has engaged in different operations on the border, especially Operation Lone Star. which has been one of the largest employment of Texas military forces, and its service members are largely comprised of National Guard dual service technicians. Due to their dual service, if a technician were to become fatally injured while performing state duties, their surviving spouse would not qualify for a homestead exemption under the current statute. What we try to seek with this legislation, members, is that the exemption to ensure that the surviving spouses of military technicians can also avail themselves of that homestead exemption in the unfortunate event that their spouse were to be killed or fatally injured in the line of duty working on behalf of our state. I believe that we have several witnesses that can speak to the necessity of the bill, and Mr. Chairman and members, I'm happy to answer any questions if there are some.
Members, any questions? I do have one. What would be a military technician? Like, what would the job duties be? Titles or?
Well, the military technicians, I understand it would be, for example, currently some of the military department members that are on the border, that we've heard a couple of incidents that have occurred, I think within the last year or two, that have lost their life in assisting. Most of them have been trying to supplant and support the current operation of DPS that is there. And that's what we're trying to do is, in the event that that has happened, unfortunately, because of the current statute, they wouldn't be allowed some of those protections. That's how I understand it, but I don't know if maybe the other witness could clarify a little bit further, but that's how I understand it, Mr. Chair.
Very good. Thank you, Representative. There is no one registered to testify. Okay, I can ask. Is there anyone who wishes to testify on, for, or against House Bill 4181? All right, seeing none, Chair recognizes Representative Munoz to close on House Bill 4181.
Thank you, Mr. Chairman, members, and I guess I thought there would be somebody here from the military department, but I will go ahead and make sure I have that information correct for yourself and the rest of the members. But with that, I close and would happy to answer any other questions that would arise even after the hearing. And there is a Senate companion also of this bill that has also been filed.
Very good, Representative. Yeah, if you don't mind just getting us that information, that'd be great. If there's no objection, House Bill 4181 will be left pending. Is there objection? Chair hears none. House Bill 4181 is left pending. Chair lays out House Joint Resolution 165 and calls on Representative Munoz to explain the joint resolution.
Thank you, Mr. Chairman and members. And this also is a legislation in regards to the veteran spouse market value. The HJR 165 will propose the constitutional amendment to the voters this coming November that would authorize the legislature to provide for an exemption from ad valorem taxation of all or part of the market value of the resident homestead of the surviving spouse of a military service member who is killed or fatally injured in the line of duty. There's also a Senate joint resolution that has been filed by Senator Paxton, which is also the enabling legislation for another Senate bill regarding this. But this is what the House joint resolution would do, and this, along with the prior bill, was also a work that was done during the interim, working with the Defense and Veterans Affairs Committee and trying to bring it forth this session for passage.
Thank you, sir. Members, any questions? Is there anyone who wishes to testify on, for, or against House Joint Resolution 165? Seeing none, Chair recognizes Representative Munoz to close on House Joint Resolution 165.
Thank you, Mr. Chairman and members. With that, I close. And again, if there's any other questions, I'll go ahead and work with the committee and members on it. Thank you.
Very good. Thank you, sir. If there's no objection, House Joint Resolution 165 will be left pending. Is there objection? Chair hears none. House Joint Resolution 165 is left pending.
2398.
Okay. Mr. Hefner. Chair lays out House Bill 2398 and calls on Representative Hefner to explain the bill. Yes, sir.
Thank you, Mr. Chairman and members. Thank you all for hearing my bill today. This bill would simply allow the grieving family members of a surviving spouse or surviving children to reapply for their land to be appraised for agricultural use after the deadline of May 1st of the year, so that they do not incur a higher tax bill on qualifying land. Currently, when a property owner who receives a special valuation passes away, it is considered a change in ownership, even if the property is inherited by the surviving spouse or surviving children. Therefore, this change will trigger the grieving family to reapply for open space evaluation before May 1st of the year. If the application is not received in a timely manner before the deadline, then the family members incur a higher tax bill on their qualifying land for the year. 2398 would seek a solution to this unfortunate situation for Texans that use their land for agricultural purposes, as the language of HB 2398 would allow these grieving family members the opportunity to have their land reappraised following the death of their loved one for the continuation to qualify for the special valuation of open space. My bill would only affect new ownership of the land that was inherited by a surviving spouse or surviving children following the death of a previous owner. This is similar to the bill that we're looking at voting on today, but the difference is between the two is that 2354 allows us to do the auto transfer if we 2354 made it where the open, let me just read the script. That'll be better, wouldn't it? The difference between the two is that 2354, which is the one we're voting on later, also allows us to do the auto transfer if we know at the time that the new owner's surviving spouse or surviving child. And 2398 gives us authority in case we miss that it is a surviving spouse or child and don't catch it until after the certification. So this is just kind of a safety net in case we miss it.
All right, members of Chair calls Brent South.
Brent South, Texas Association of Appraisal Districts, here in support of House Bill 2398. And last time you'll have to see me today, I promise. Yes, this is just it's a step 2 to House Bill 2354, which was heard last week. 2354 allows us to do the auto transfer if it's going to a surviving spouse or surviving child. However, there may be instances where we don't catch that the ownership transfer is to a surviving spouse or surviving child. So in those situations, we would now have the authority after the deadline to allow those property owners to still apply for and be qualified for the agricultural use appraisal that year. So thank you, Representative Hefner, for filing this bill. This is a very taxpayer-friendly bill that's helpful to our property owners.
Very good. Thank you, Mr. South. Members, any questions? All right, thanks, sir. Is there anyone else who wishes to testify on, for, or against House Bill 2398? Seeing none, the chair recognizes Representative Hefner to close on House Bill 2398.
Thank you, Mr. Chairman. I close.
Thank you. If there is no objection, House Bill 2398 will be left pending. Is there objection? Chair hears none. House Bill 2398 will be left pending.
Next, 2981.
Chair lays out House Bill 2981. Chair offers a committee substitute and calls on Representative Hefner to explain the bill.
Thank you, Mr. Chairman. The Comptroller of Public Accounts mails approximately 125,000 hearing notices and more than 800,000 franchise tax delinquency notices annually. Committee substitute to 2981 amends the tax code to allow the comptroller, at the request of the individual, to send certain notices by email rather than mailing paper copies. Said email would be sent to what is on file at the comptroller's office. The committee substitute makes technical changes that allows the office to email notices of permit suspension or revocation and make service of notices complete with when the comptroller transmits the notice to the person's email address or places the notice in the mail. And it adds provisions allowing the office to email or mail notices of forfeiture or corporate privileges and make service complete with the email is sent or notice is placed in the mail. It also allows the comptroller's office to send notices by email, or allowing the comptroller's office to send notices by email modernizes the notice process, increases efficiency, and reduces mailing expenses to the state. And be happy to answer any questions and reserve the right to close.
Very good. Thank you, Representative. Members, any questions? Is there anyone who wishes to testify on, for, or against House Bill 2981? Seeing none, the chair recognizes Representative Hefner to close on House Bill 2981.
Thank you, Mr. Chairman. If y'all see fit, when it comes time to vote, we'd love to send this to local if the committee sees fit, and I close.
Very good. Thank you, sir. The committee substitute is withdrawn. If there's no objection, House Bill 2981 will be left pending. Is there objection? Chair hears none. House Bill 2981 is left pending.
3273.
Chair lays out House Bill 3273. The chair offers a committee substitute and calls on Vice Chair Theory to explain the bill.
Thank you, Chairman Myers and members of the committee. I appreciate the opportunity to lay out committee substitute House Bill 3273. The intent of House Bill 3273 is to increase the efficiency and transparency of tax rates for property owners in Texas. We've heard a lot about that today. This legislation will make it easier for property owners to understand and assess their tax rates while decreasing costs to the state. For background, Property Tax Code Section 2617 requires appraisal districts to mail postcards to all property owners by August of every year. These postcard notices provide relevant information, including taxing unit budgets, tax rates, and information on hearings, which can be viewed on the internet. Postcard mailing costs, like all appraisal district operating costs, are funded by property tax revenues. Last year, large metropolitan counties spent over $4 million on the postcards alone. This bill addresses both cost and efficiency. In lieu of postcards, House Bill 3273 would require posting the identical postcard language prominently on appraisal districts and taxing units' websites, as well as posting the information on physical mailed hearing notices, as well as also publishing it in a newspaper of general circulation. The committee substitute would also change the August 7th deadline for delivery to September 1st to allow for more time to actually have the detailed information on the website once the property tax owner receives the information and is directed to go and look it up. They're wanting to have more information on them to actually view. Oops, excuse me. In conclusion, 3273 will increase the efficiency and transparency of tax rates for property owners in Texas while decreasing costs. The implementation of these varied methods of communication will provide public awareness, transparency of the rate setting process while saving taxpayers' money. With that, members, I am happy to answer questions. However, we do have some witnesses here from various appraisal districts, I believe, and I reserve the right to close.
Very good. Thank you, Vice Chair Theory. Chair calls Paul Pennington.
Mr. Chairman and committee members, again, my name is Paul Pennington from Carrollton, Texas. I'd like to read a brief statement about the Citizens for Appraisal Reform's opinion of this bill. We support this bill. We believe providing tax relief and fairness. We believe in tax relief and fairness to taxpayers. This helps increase notices to taxpayers regarding the property tax database, increase taxpayer awareness information related to their property taxes and applicable rates. So we just wanted to go on the record and support this bill.
Very good. Thank you, Mr. Pennington. Members, any questions? All right, very good. Chair calls. Okay. Chair calls Roland Altinger.
For the record, Roland Altinger, the president of the Texas Association of Appraisal Districts and the chief appraiser for the Harris Central Appraisal District. Chairman Meyer, members of the committee, I'm testifying in support of House Bill 3273, which would add several low-cost forms of notice to property owners of web locations of tax transparency databases created by Senate Bill 2 in the 86th legislative session. The bill amending Property Tax Code Sections 26.04E2 would replace current postcard notice, saving Texans across the state millions in material, handling cost, and postage. Making tax rate adoption more transparent to property owners, SB 2 sought to increase their meaningful participation and comment since property owners were paying the bill. Each CAD was required to create and maintain databases, making it easy access to tax units' websites and info including budgets, past and proposed tax rates, hearing dates, and how to comment remotely. To alert taxpayers of the database, SB2 required written notice be delivered by August 7th, which of course is September, and the change of this to all property owners. Recognizing tendency in the public to not recognize the postcard as an official notice. The 87th legislative session tweaked the notice language to direct the public to texas.gov to find the local databases. A postcard is a postcard. No statute can fundamentally change the fact. We agree with the last legislature's absence close examination. The official nature of the card can be overlooked. That extent is debatable. What cannot be denied is the annual cost of the postcards are significant. Last year alone, Harris Central Appraisal District mailed 1.4 million cards, costing over $671,000. 47 cents a card. Statewide, when you look at the information Representative Theory laid out, is the MetroCads, which is a $4.1 million savings. But if you take the comptroller's website of the 21 million parcels statewide, that's an annual savings of almost $10 million. Taxpayers are already squeezed by inflation, affecting CAD operation cost, needed to timely deliver certified tax rolls and provide due process. Affected costs include labor, increased protest, added technology to secure our data against cyber criminals. And we all need to do our part to hold costs down for taxpayers and taxing units we serve. House Bill 3273 is a great venue. The same transparency, notice language would appear on CAD websites, taxing unit websites, value notices, and general circulation newspaper, raising public awareness at little to no cost. Also, email notification of transparent database updates and postponing the notice of September 1st of this year, where more meaningful data would be available on the tax unit's website. I sincerely request your support to save Texas money while providing meaningful multi-channel notices of the rights to participate in setting local tax rates. I'd be glad to answer any questions, Chairman Meyer, or any other members of the committee.
Very good. Thank you, sir. Members, any questions? All right, seeing none. Oh, I'm sorry. Do you have a question, Representative Shine?
No, I won't put him on the spot.
All right, very good.
Thank you, Representative Shine.
All right, thank you, sir.
That's anyone else.
Is there anyone else who wishes to testify on, for, or against House Bill 3273? If not, the chair recognizes Vice Chair Theory to close on House Bill 3273.
Thank you, Mr. Chairman. Members ask that this bill be voted favorably out of committee. And with that, I respectfully close. Thank you.
Thank you. Committee substitute is withdrawn. If there is no objection, House Bill 3273 will be left pending. Is there objection? Chair hears none. House Bill 3273 is left pending.
3640. That should be it. Yep. There you go.
Chair lays out House Bill 3640. The chair offers a committee substitute and calls on Representative Noble to explain the bill.
Thank you, Mr. Chairman, and members for giving me the opportunity to lay out House Bill 3640. I'm laying out as you said, I'm laying out a committee substitute today. Most every adult who owns a home in Texas and resides in that home benefits from the resident's homestead exemption when it comes to paying their property taxes on that home. Unfortunately, we do have a very narrow population of Texas adults who do not qualify for that same benefit, and that population is our adults with intellectual and developmental disabilities, known as IDDs. I understand everyone may not be familiar with the term IDD, but I bet we all know and love someone with intellectual and developmental disabilities. The parents of IDD adults are the only parents who are afraid to die before their children. In an effort to care for their adult loved ones with IDD and provide for their future, some parents, siblings, or other family members have purchased a home in which their loved one can live and be cared for on a daily basis. House Bill 3640 would extend a property tax exemption equal to the amount of our existing homestead exemption to a family member who owns a home
owns a residence for the benefit of an adult with IDD who resides there. Some of our most vulnerable Texans are adults with intellectual and developmental disabilities residing in their own home cannot qualify for the homestead exemption because having the home in their name would cause them to lose some of their federal and state benefits, believe it or not, benefits they greatly need and greatly deserve. My legislation requires that to qualify for the property tax exemption, the home must be the primary residence of the adult with IDD and requires that the owner or trustee of the home must be related to the adult with IDD within the third degree of consanguinity. And I had you hand out a diagram of that so you can understand what that means. At 9 a.m. this morning, just an hour prior to our committee starting, I got a doozy of a fiscal note. And I want to make this very clear. It is not the intent of this bill to give additional exemption to the home of someone that already has a homestead exemption. And that's what the comptroller or whoever, the LBB, thought when they did that fiscal note. This bill is simply to give an equivalent exemption to a primary residence of adults with IDD, homes owned by family members, homes that are not currently getting a homestead exemption. I'm going to be proposing a change in the bill's language to make that abundantly clear and anticipate the fiscal note will disappear with that revision. I'm happy to answer any questions you have, and I reserve the right to close.
Chair recognizes Representative Raymond.
Thank you, Chairman. I was going to say I'm willing to bet the fiscal note's wrong, and so I'm glad you're working with them on that. I don't know if LBB's here or controller or somebody, LBB, but I want to thank you for doing this. This is I'm just really glad you're doing it. A lot of us have spent a lot of time, working with this community, and I was very proud to join my friend who's not here anymore. Come on, Rich. Vicki Truitt. We passed this bill. We passed a bill together to change it, the language to respectful language to IDD and intellectual developmental disabilities. And Governor Perry wanted to do a bill signing. We did a bill signing with him. So I'm glad you're doing this. It would be a tremendous help to people out there and folks who can, families or others who can help them. Well, I guess families who can help them set up a home like this. It's just tremendous. It's great, and I just want to thank you for doing it. And I want to make sure that LBB works with us to fix this fiscal note.
I can't think of a more deserving population to have a homestead exemption equivalent on their homes.
Absolutely, and then when you look at the whole picture, the state will end up saving money. I mean, it's a lot of things. Yeah.
Thank you.
Members, any other questions? Very good. Thank you, Representative Noble. Chair calls Rebecca Holland.
Thank you so much for this opportunity to visit with y'all, and thank you, Representative Noble, for proposing this bill. I'm here to support it, and I'm just here to paint a quick picture of what this looks like. I'm the legal guardian for my brother, Jim. He has severe IDD and autism. He functions probably on the level of a 2-year-old. Several years ago, both our parents passed away, and I took over guardianship of him. It was their wish to turn our family home into a group home for him so that Jim could benefit from the stability, familiarity, and comfort of home. As Representative Noble told you, he cannot have assets in his name, and so they left the home to me. It's in my name, and I took on the task of going out and finding a provider, a group home provider. That's a group of people that will come into the home and take care of the disabled 24/7. And so this was a very difficult task several years ago, and as I understand it, it's even more difficult now. Many providers are quitting, shutting down for several reasons. One of the biggest being how difficult it is to hire and retain staff due to low direct care wages for our group home staff. But one thing that I was able to offer a group home provider, which was an incentive to this group home provider, was very low rent. I charge my provider $500 a rent for, $500 a month for rent for a home that should rent for $2,000 a month. This home is in Rockwall, Texas. I actually live in Hawkins now, but my family of origin is from Rockwall. And so that home should rent for $2,000 a month. And 3 years ago, that did barely cover the taxes and insurance. But last year, the tax appraisal went up $98,000, or not the value of the home went up $98,000 on the home alone. So my taxes increased significantly, as you can imagine. And then you can add that homeowner's insurance, appliance repairs, lawn maintenance, AC repairs. I lost several $1,000s last year maintaining that home. And I don't have the heart to raise rent on my group home provider. There's already cost of living and inflation, and she already has trouble getting workers. I can't do it. So not all families have the ability to do what I do, but if we can help and encourage those that do in any way, it's going to enable me to continue providing low rent, the lowest rent possible to my group home provider, which encourages her to stay in business. It also ensures that I'm very involved in my brother's life and his home. And so it just all the way around has positive benefits for this community. And I'm really grateful and thankful for your consideration of this.
Very good. Members, any questions? And thank you for what you do, ma'am.
Thank you.
Bramlett. Ann Bramlett.
The chair calls Ann Bramlett.
Thank you for letting me share about this important bill, and I appreciate Representative Noble filing it. And it was really a surprise, a pleasant surprise. It made me realize that you guys really listened to us when we talked to you, and I'm very grateful for that. I wanted to add something to Rebecca, what she just said. Not only is it helping her brother, it's helping the other individuals in the home whose families might not be able to do this. And so it's been really blesses more than one person. It helps other people. And so what I wanted to tell you, I get to skip telling you what the bill was because she told you, but in case you don't know what IDD is, it's the population, people with Down syndrome, autism, intellectual challenges that would be related to having an IQ below 70. And in Texas, about 3% of the population is going to have IDD, and out of that 3%, about 5% will be severe and profound, kind of like Rebecca's brother and my son. So my son is 39, his name is Sam, and he lives in the home that I own. And I have found over the years working with families, they buy homes for different reasons. One of them is we want our kids closer. The closest I could get Sam before this was Oak Cliff, and there's nothing wrong with Oak Cliff, it's just it was over an hour for me to drive to see him, to keep him involved in the community. And if he was having a hard time or a medical emergency, I might be having to drive forever to get to him. So I really kept wanting to get him closer to me in Collin County. And I found the only way I could do it was take some money out of retirement and get a home loan. And I was blessed that I did it when the rates were a little bit lower and the house was only $140,000. So, I can't even imagine I did that, but I did it. And it's worked out okay. But anyway, we do it because we want our children closer. We do it like with Rebecca's situation, somebody passes away or you downsize and you want to keep your child or loved one in a stable situation. But another reason we do it is to keep the rent down, because I found that by me buying the house and keeping the rent down, I could get a provider. I couldn't get a provider in Collin County because they couldn't get a house. They couldn't afford one. So this is a way I could help them do that. But as she was mentioning, I charge low rent. I've kept it that way for a long time, and I've been kind of shocked over the last couple of years because now I'm in the red every year doing repairs. And I just kind of have a lot of faith that God is going to take care of a lot of that. But part of the way we take care of it is let people know when we need help. So I would really like to see this bill pass so that we can maybe get a little more control over our property taxes. Because whatever money we ever do make, which I'm not having any profit at this point is I just keep it in that account for repairs. So I've replaced the heat and air, I've replaced the roof, I've replaced the fences. I've done all kinds of things to make it be a safe and good environment for the guys living there. So when we pay rent, like she's saying, it's just for mortgage. A lot of people I know that have done this, they're still paying mortgages. So they're paying a mortgage and the repairs. And a lot of these people are my age or older. So I'm almost 70, and there are a lot of people in their 70s and 80s that are doing this and struggling on a fixed income to pay these expenses. So anything we can do to help slow down the growth of those kind of expenses would be helpful. So I'm very much in support of this bill. I also want to say that this keeps people, in my mind, a lot of people from having to go into an institutional placement, because there are people in Texas that want a group home and they can't find one. And if the parents are in a situation where they can no longer take care of them, sometimes your only recourse is to go to a state-supported living center, even though they could have been served in the community. Now, sometimes somebody may need to go to a state-supported living center, at least for a while, but it shouldn't be because we can't find a home in the community. So we want to do everything we can to support those people that can figure out a way to do it in as most cost-effective way possible. So if anybody has any questions, I'd be happy to answer any questions.
Very good. Thank you, ma'am. Members, any questions?
Thanks for your support.
Thank you. Appreciate it. Chair calls Tom Forbes.
Thank you, Mr. Chairman. My name is Tom Forbes. I'm a lawyer here in Austin, and we're fortunate to have a wonderful son who deals with intellectual disabilities, and many of you may know him. He works in the Capitol and is a delightful, wonderful human being and a wonderful son. His ability to be independent is very important to him and to us. It makes him his ability to be a productive citizen and a taxpayer is also very important to us. And the more independent that he can be, the better he is. And we have been able to provide a place for him to live pretty independently. And in order for him to continue to do that, this bill would be very supportive of that, and we support it and want to do whatever we can to assist you, Representative Noble, in getting it passed. Matthew's ability to be independent adds to his quality of life every day, and this bill would assist him and help to ensure that he can be as independent as he can possibly be for as long as he possibly can. I'll be happy to try to answer any questions.
Thank you. Members, any questions? And Mr. Forbes, two things. Once, you registered twice, okay? We have your permission to combine registrations?
Yes. When I first registered, I didn't think I would be able to be here to testify.
Okay, very good. And secondly, I know I speak for everyone on this committee that we appreciate Matthew's service as a sergeant on the House floor. He is a delight every single day. So
thank you very much. We're very, very proud of him.
Thank you, sir. Is there anyone else who wishes to testify on, for, or against House Bill 3640? If not, the chair recognizes Representative Noble to close on House Bill 3640.
It is really important that we make sure that these homes do not have to pay full commercial property values on their property taxes. These are homes for individuals. They're not homes for making money. And I think that it's really important and really exciting that we get to have a voice in that. I respectfully request passage.
Very good. Thank you. Committee substitute is withdrawn. If there's no objection, House Bill 3640 will be left pending. Is there objection? Chair hears none. House Bill 3640 is left pending.
3709.
Chair lays out House Bill 3709 and calls on Representative Noble to explain the bill.
Thank you, Mr. Chairman, Vice Chair, and members for allowing me the opportunity to lay out House Bill 3709. Members, when owners of historic buildings make a decision to rehabilitate a deteriorating property, they face some financial burdens due to the additional hurdles one must navigate in order to make changes to a building that's been designated historical. Our state's historic tax credit helps put empty and underutilized buildings into public use, so they will contribute to our state and local tax base. We've had a total of 355 projects certified statewide since the inception of this program in 2015. These buildings that otherwise would be underused, unused, or even derelict. The state historic tax credit is currently wholly contained within Chapter 171, the franchise tax section of the tax code, and the credit can be taken against either the franchise tax or insurance premium tax. House Bill 3707 would simply transfer the historic tax credit from Chapter 171 to a new Chapter 172 with no other substantive changes. Each session, bills are filed that would repeal the franchise tax. It's an exciting opportunity. Hopefully, we will get that done at some point. And moving this important tax credit out from underneath the franchise tax code would protect this vital program in the event that the franchise tax is repealed. And we have resource witnesses today here from the Texas Historical Commission, if needed, and I am happy to answer any questions and reserve the right to close.
Members, any questions? I just, again, want to confirm it's House Bill 3709 that we're.
3709.
Very good, thank you, ma'am. Chair calls Vaughn Aldridge.
Mr. Chairman, Vaughn Aldridge, Texas Historical Commission, on the bill, resource witness, answer questions particularly that might have to do with the fiscal note. The LBB is saying that it's possible or probable that there will be a larger pool of nonprofits because there's a change in definition between 171 and the newly written 172. Was not our intent to increase the pool. The legislature affirmatively made the historic tax credit available to nonprofits. We were given the definition inside Chapter 171. Now we've got a slightly different definition. We're going to support the work of any building owner that is a nonprofit. It's not a judgment that we make. It's a comptroller's judgment under the law. So that concludes my, unless anybody's got any questions.
Very good. Thank you, Mr. Aldridge. Members? All right, thank you, sir. Chair calls. Is there anyone else who wishes to testify on, for, or against House Bill 3709? No. If not, Chair recognizes Representative Noble to close on House Bill 3709.
Thank you, Mr. Chairman. I respectfully ask for a favorable vote on this, and I close.
Very good. If there's no objection, House Bill 3709 will be left pending. Is there objection? Chair hears none. House Bill 3709 is left pending. Chair lays out House Joint Resolution 150. Chair offers a committee substitute and calls on Representative Noble to explain the joint resolution.
Thank you, Mr. Chairman, Vice Chairman, members. HJR 150 would place a constitutional amendment on the November ballot, would allow the people of Texas to vote on extending our property tax exemption equal to the amount of our existing homestead exemption to a family member who owns a home used as the primary residence for an adult with IDD. And I'm happy to answer any questions. And you have and reserve the right to close.
Members, any questions? Is there anyone who wishes to testify on, for, or against House Joint Resolution 150? If not, Chair recognizes Representative Noble to close on House Joint Resolution 150.
Thank you, Mr. Chairman. I respectfully request passage.
Thank you. The committee substitute is withdrawn. If there's no objection, House Joint Resolution 150 will be left pending. Is there objection? Chair hears none. House Joint Resolution 150 is left pending.
Never voting.
Okay.
We got everyone.
Perfect. Members will now vote out several bills which we have heard in previous hearings. Okay. Chair lays out as pending business House Bill 2249. Members, this is the bill by Chair Metcalf. Representative Noble moves that House Bill 2249 without amendment be reported favorably to the full House with the recommendation that it do pass and be printed and be sent to the Committee on Local and Consent Calendars. Clerk will call the roll.
Chair Meyer.
Aye.
Vice Chair Theory.
Aye.
Button.
Aye.
Craddock.
Aye.
Gervin Hawkins. Hefner. Munoz. Noble. Raymond. Shine. Turner. 11-0.
There being 11 ayes, 0 nays, the motion prevails. Chair lays out as pending business House Bill 2354. Members, this is the bill by Representative Hefner. Speaker Craddock moves that House Bill 2354 without amendment be reported favorably to the full House with the recommendation that it do pass and be printed and be sent to the Committee on Local and Consent Calendars. Clerk will call the roll.
Chair Meyer.
Aye.
Vice Chair Theory. Button.
Aye.
Craddock.
Aye.
Gervin Hawkins. Hefner.
Aye.
Munoz. Noble. Raymond. Shine. Turner. 11.
There being 11 ayes, 0 nays, the motion prevails. Chair lays out as pending business House Bill 2674. Members, this is a bill by Representative Kitzman. Chair Button moves that House Bill 2674 without amendment be reported favorably to the full House with the recommendation that it do pass and be printed. Clerk will call the roll.
Chair Meyer.
Aye.
Vice Chair Theory. Button.
Aye.
Craddock.
Aye.
Gervin Hawkins. Hefner.
Aye.
Munoz. Noble. Raymond. Shine. Turner. 11-1. 11-0.
There being 11 ayes, 0 nays, the motion prevails. Chair lays out as pending business House Bill 2691. Members, this is a bill by Chair Button. Representative Gervin Hawkins offers a committee substitute. Is there objection to the adoption of the committee substitute? Chair hears none, and the substitute is adopted. Representative Gervin Hawkins moves that House Bill 2691 as substituted be reported favorably to the full House with the recommendation, that it do pass and be printed. Clerk will call the roll.
Chair Meyer.
Aye.
Vice Chair Theory. Button. Craddock.
Aye.
Gervin Hawkins. Hefner. Munoz. Noble. Raymond. Shine. Turner. 11-0.
There being 11 ayes, 0 nays, the motion prevails. Chair lays out as pending business House Joint Resolution 132. Members, this is a joint resolution by Representative Hefner. Representative Shine offers a committee substitute. Is there objection to the adoption of the committee substitute? Chair hears none. Substitute is adopted. Representative Shine moves that House Joint Resolution 132 as substitute be reported favorably to the full House with the recommendation that it do pass and be printed. Clerk will call the roll.
Chair Meyer.
Aye.
Vice Chair Theory. Button.
Aye.
Craddock.
Aye.
Gervin Hawkins. Hefner.
Aye.
Munoz. Noble. Raymond. Shine. Turner.
No.
8-2.
There being 9 ayes. I'm sorry, there being 8 ayes, 2 nays, the motion prevails. Chair lays out as pending business.
We're going to skip this one. That's done. That's you're done. That's it. We're adjourning.
We don't want to do this one.
Okay, go ahead. 2763.
Okay. Chair lays out as pending business House Bill 2763. Members, this is the bill by Chair Guillen. Representative Hefner moves that House Bill 2763 without amendment be reported favorably to the full House and the recommendation that it do pass and be printed. Clerk will call the roll.
Chair Meyer.
There being, aye.
Vice Chair Theory.
Aye.
Button. Craddock.
Aye.
Gervin Hawkins. Hefner.
Aye.
Munoz. Noble. Raymond. Shine. Turner. 10-0.
There being 10 ayes, 0 nays, the motion prevails.
That's it.
Members, is there any other business to be discussed before we adjourn? Seeing none, Chair moves to adjourn. Is there objection? Seeing none, having no further business and hearing no objection, the House Committee on Ways and Means stands adjourned, subject to the call of the Chair.